For more than 4 decades, I have had the privilege of representing individuals and families whose lives were upended by tragedy, negligence, and corporate misconduct. I have built a prominent personal injury practice in Chicago, representing the families of those who have died in major plane crash events, and representing many others injured in vehicle collisions, by medical malpractice, and more. I have found in my career that the legal system provides a singular opportunity for those who seek justice for the aggrieved. The system places an enormous burden on those lawyers who enter the fray and fight for what is right, and few have the grit required to succeed. Matt Moyer, one of those lawyers, has joined our ranks at Clifford Law Offices, and we are glad to have him. In this book, Matt pulls back the curtain on his experience as an attorney in the criminal justice system with an unflinching honesty and clarity that is rarely found in print. As a former Cook County prosecutor and federal prosecutor, Matt knows the criminal courts of Chicago from the inside. He has seen how justice prevails and falls short not only in the courtroom, but also behind the scenes, in the daily grind. His book captures the unpredictable drama of courtroom stories, which are sometimes tragic, sometimes absurd, sometimes uplifting. He reminds us through his stories that doing justice is not an abstract endeavor, but a messy, winding road that only the most perseverant and dedicated attorneys manage to plod with skill. What distinguishes this book is not just the stories themselves, but the perspective from which they are told. Matt writes with the clarity of a lawyer who has lived the battles, but also with the eye of a storyteller who knows that behind every case file, there are real people on all sides of the case affected by the system. Readers will find themselves immersed not only in the drama of high-stakes litigation, but also in the overlooked reality of how cases are prepared, delayed, argued, and resolved. The justice system is far from perfect. Anyone who has spent time inside of it knows the frustration of the red tape, bureaucracy, and maddening obstacles that can stand between citizens and their day in court. And yet, for all its flaws, it remains the one institution where the downtrodden can demand accountability from those who have wronged them. Matt's accounts underscore this truth while reminding us just how fragile and how essential the balance really is. I am proud to introduce this work. It is at once a personal memoir, an insider's guide, and a candid portrait of the courts as they actually function. For lawyers, it offers a mirror of the profession we know all too well. For the general reader, it opens a window onto a world that is rarely explained with such precision and humanity. Robert, a Clifford founder, Clifford Law Offices, Chicago, Illinois. Introduction. The backdrop of this book is Chicago, a city of beauty and charm, turmoil and chaos. The Windy City. Its skyline of glass and steel rise above a city built on grit, Midwestern values, and barely restrained havoc. Beneath the majesty of its towering skyscrapers lies a sprawling patchwork of neighborhoods and blocks, each with a litany of stories spanning back across the decades. Between the carjackings, cold-blooded homicides, daring bank robberies, and white-collar fraud schemes, the crime here is as varied as it is enduring. This book will give a first-hand account of how criminal cases are built by cops and federal agents. It will show you how defendants are hauled into court, and how criminal prosecutors wage war in the courtroom to obtain justice. In this world, the truth is stranger than fiction. This book is a window into that world for curious citizens, aspiring lawyers, and anyone who wants to understand how justice is carried out in one of America's most complex, historic cities. Although I am now a personal injury attorney in Chicago, I look back with pride on my days as a criminal prosecutor, and it is my honor to provide you with a glimpse into this world. Let's start with the basics. What exactly is a criminal prosecutor? Prosecutors are government attorneys tasked with bringing criminal charges in court based on evidence gathered by law enforcement. The job is not to win at any cost. It's to pursue truth and justice, nothing else. That means working alongside police officers, detectives, or federal agents to identify perpetrators, gather admissible evidence, file formal charges, and, if necessary, take the case to trial. When a defendant pleads guilty or is found guilty at trial, the prosecutor then advocates for an appropriate sentence before the judge, often a term of imprisonment. Prosecution has 2 dimensions. The first is the reactive role, which most new prosecutors take on early in their careers. In reactive cases, police officers do the front-end work. They investigate crimes, make arrests, and write up detailed reports. The prosecutor then reviews the file to determine whether there's enough evidence to charge the defendant and whether everything was done constitutionally. For example, in a DUI case, an officer might pull over a car swerving down the road. After the driver fails a field sobriety test, walking unsteadily, failing to follow the cop's finger with his eyes, and blows well over the legal limit on a breathalyzer, the officer arrests him. That entire encounter is documented in reports, which land on the prosecutor's desk the next morning. The prosecutor must ensure the stop was lawful, and the evidence is strong enough to move forward. These cases don't require involvement in the ongoing investigation, which is why they're often handled by younger, less experienced attorneys. The second role is investigative, and it's where the job becomes highly strategic. Here, prosecutors are brought in at the ground floor of an active investigation. They work closely with law enforcement to shape how the case unfolds. They help determine what evidence will hold up in court, what legal theories will support charges, and how best to build a case that forces a guilty plea or stands up at trial. They also draft warrants to search homes, seize phones, and gain access to social media accounts. Once a judge signs off, agents move in to execute the searches. Prosecutors interview witnesses, review records, and help make sense of evidence as it comes in. My most rewarding cases were the ones where I was involved from day one, working with agents, interviewing witnesses myself, and piecing together the puzzle. I did not start out as a prosecutor. Out of law school, I was hired by a high-paying corporate law firm. The firm mainly handled disputes between Fortune 500 corporations. It came with an internship in my final summer of law school, where my peers and I were wined and dined all summer to convince us to come aboard. It worked. Once working there full-time, I found the partners and older associates I worked under to be perfectly agreeable and skilled at what they did. In my sole year at this firm, I never suffered the overwhelming workload that often comes with corporate litigation. I was having a nice enough time, but something was missing. This job did not enable new attorneys to fight battles in court. Every day, I dreamed of the action and drama of the courtroom. I always had. As early as high school, I set my sights on becoming a criminal prosecutor. I envisioned myself enmeshed in great battles with opposing counsel over significant cases. I knew that, at my corporate litigation gig, I would not enter a courtroom until I became a seasoned, high-ranking law firm partner due to the gravity of speaking for high-paying Fortune 500 clients in court. After only a year, I walked away from the job with a staggering salary and a stunning office view of the Chicago skyline to immerse myself in the gritty work of state prosecution. My new salary would be less than 1/3 of what it was before. I relished my time as a state prosecutor, which I describe in this book. As you will see, criminal court in Chicago is a fairly chaotic place. In the trenches there, I fought many uphill battles, and against all odds, prevailed from time to time. After a few years as a local prosecutor in Chicago, I submitted a long-shot application to become a federal prosecutor at the young age of 28. I am told that for any given opening for a federal prosecutor spot, up to 1,000 attorneys apply. I was lucky enough to be selected for the job, where I would continue my prosecutorial work, handling more complex cases, working with the FBI and other federal agencies to ferret out wrongdoing in the Windy City and beyond. During that time, I investigated and charged criminal cases that received local, national, and even international media coverage. I could not have guessed how much my decision to embark on this crime-fighting path would change my life. 2 weeks into my new job as a prosecutor at the state's attorney's office, I was told I would be getting an office in it, stationed at the desk a few feet away from me. Great, I thought. I'll have to make idle chatter with someone day in and day out instead of getting my work done. At my comfy private practice job, I had an office all to myself. What a downgrade, I thought. But then, the day before my new office mate started, they posted her name on the door. I Googled her and found a picture of her from social media. She looked cute. On her first day, we got on famously, and the rest is history. We started off intent on avoiding a workplace romance, but changed our plans. We dated for 2 years and then got married, deciding to make a life together in the Chicagoland area. Before we were married, we lived in the West Loop neighborhood of Chicago, in different apartments, but right down the street from each other. While living there, both working as criminal prosecutors, we had a shocking brush with the criminal underworld that was not supposed to occur outside of working hours. My then girlfriend called me to tell me she was driving over to my apartment and would be there in a couple of minutes. I got another call from her moments later, too quickly for comfort. She was frantic, yelling, "Oh my God! Oh my God! Go out to the balcony, look out the window." I went to the balcony and looked down at the road. I saw her car stopped at the intersection by my place. Around her, on the ground, I saw several people clutching themselves, lying on the pavement. They were screaming, and I could see blood pooled around them on the pavement. I ran downstairs and found several cars stopped around her car, most of them with bullet holes lodged in their exteriors. My now wife was totally unharmed, and her vehicle was not struck with gunfire, but those around her were not so lucky. We later learned how and why bullets had flown at this intersection on that day. Right as my wife was pulling up to the intersection of Grand and Milwaukee, 3 cars full of rival gang members spotted each other. They proceeded to engage in a movie, like shootout with each other, as they drove through the streets. My wife recalled seeing an arm hanging out the window, holding a gun, firing indiscriminately in all directions. She was confused when she learned it was a gang fight, because it seemed to her that the shooter was aiming at the pedestrians. Not long after this incident, we moved to the suburbs, bought a golden retriever, and got married. There, my personal life took a peaceful turn, which served as a nice contrast with the gritty work I handled day to day. The drive, by shooting incident, was a collision with an underworld that I only ever wanted to interact with during the workday. While many Chicagoans live their whole lives untouched by violence, most move through the city with the uneasy sense that danger is always just out of view, watching, waiting. Today, I am a personal injury attorney in Chicago. But through this book, I reflect on my days as a crime fighting lawyer who fought his best to bring order where there was chaos and safety where there was danger. The Windy City. Many individuals who come into contact with the criminal justice system in Chicago begin their path at a young age. In neighborhoods marked by generational poverty, underfunded schools, and the daily threat of violence, young boys begin making choices that will shape their lives long before they fully understand the stakes. In some of Chicago's most crime-ridden areas, places like Englewood, North Lawndale, Auburn, Gresham, and Austin, adolescents are often raised in homes fractured by incarceration, addiction, or economic despair. With few stable male role models in the household, boys look outward, to older siblings, neighborhood figures, or guys on the block. These older boys sometimes provide protection, money, and a form of masculine identity. They show off guns, post photos with wads of cash on Instagram, or film YouTube videos rapping about the shootings they committed. To the unformed mind of a 12 or 13-year-old, this begins to look not only normal, but aspirational. The path to violence rarely starts with one decision. It's more often a slow absorption into a culture where respect is earned through aggression and where conflict is handled through intimidation or retaliation. The young boy who starts out carrying a backpack full of drugs for a cousin eventually gets handed a gun, just to hold it for a minute. Later, he's expected to use it. By the time he's 16, he might already be on a rival's radar due to an insult posted on Facebook or a friend's beef that he inherited. And once he's involved in a shooting, either as the shooter or the intended victim, his future is all but sealed. At that point, it becomes almost impossible to walk away. In many of these cliques, being seen as soft or even simply uninvolved can be a death sentence. Street gangs have always shaped the landscape of urban crime in Chicago, but their form and function have evolved dramatically. Today's cliques are small, fractured groups, tight-knit crews that operate on a hyperlocal scale, sometimes consisting of no more than 10 or 20 members. They feud over street corners, social media slights, or the memory of a friend who was shot by rivals years ago. But it wasn't always like this. From the 1970s through the 1990s, Chicago's gang scene was dominated by highly structured, hierarchical organizations that resembled large businesses, or in some ways, organized crime families. The Black Disciples, Vice Lords, and Latin Kings All maintained rigid command structures with national leadership, citywide rules, and strictly enforced internal codes of conduct. These were not loosely affiliated kids with handguns and TikTok beefs. They were multi-tiered syndicates with control over entire neighborhoods. Back then, major gangs divided the city into clearly demarcated territories. Public housing developments like Cabrini Green, Robert Taylor Hoynes, Rockwell Gardens, and the Henry Horner homes were effectively gang strongholds, each one governed by a dominant group that enforced order within its ranks and waged war on its enemies. Back then, large gangs demanded loyalty, punished disobedience, and discouraged freelancing. Breaking the gang's internal rules, such as cooperating with law enforcement, skimming from drug proceeds, or violating the chain of command, could result in beatings, exile, or worse. The leaders, often shielded from street-level violence, were running multi-million-dollar drug operations that funneled heroin and cocaine into the city from national and international suppliers. While some lieutenants and soldiers lived in the very neighborhoods they controlled, the top bosses frequently purchased homes in quiet suburbs like Olympia Fields, Madison, or Orland Park, where their neighbors might never suspect the kingpin living down the block. By the early 1990s, law enforcement began to shift its focus from arresting individual offenders to dismantling the leadership of entire criminal organizations. In Chicago, federal and state prosecutors began deploying the same tools that had once taken down the Italian mafia, the Racketeer Influenced and Corrupt Organizations Act, RICO, large-scale conspiracy indictments, and cooperation, based prosecutions that aimed not just to punish, but to unravel organizations. These investigations, often spanning months or years, were built like dominoes, with one push often toppling the whole set. Investigators began with low-level gang members, using threats of lengthy prison time to secure cooperation. This tactic succeeded in making cooperators out of the criminals. Cooperators would wear hidden microphones during gang meetings, supplying law enforcement with loads of information. From there, law enforcement moved upward, gathering testimony, surveillance, and wiretap evidence to identify the individuals who orchestrated the drug operations and ordered shootings from behind the scenes. The cases were massive in scope. Federal agencies such as the FBI, ATF, and DEA worked in tandem with the U.S. Attorney's Office and local law enforcement to bring down entire leadership structures. They tapped phones, intercepted coded messages, and embedded confidential informants inside violent crews. Surveillance. Teams tracked stash house movements, money laundering schemes, and the intricate web of gun and drug traffic flowing in from other states. These were not just arrests, they were takedowns. In some cases, the entire leadership structure of the nation's most prominent gangs saw their upper ranks convicted on federal charges carrying life sentences. These victories came with unanticipated consequences. The removal of top leadership created power vacuums that were quickly filled, not by a new generation of hierarchical leaders, but by uncoordinated, younger, and more impulsive actors. The loyalty and discipline that once defined gang life began to erode. In its place emerged a great decentralization, dozens of tiny cliques, often named after slain friends or local blocks, each operating with their own code, often guided more by emotion than strategy. In today's landscape, these fractured groups dominate the violent crime narrative in Chicago. Known as sets, crews, or cliques, they provide something more complex than just a platform for crime. They offer identity, family, and belonging in a world that otherwise feels desolate, lacking in hope, and lacking in meaning. In neighborhoods where schools have metal detectors and grocery stores have shuttered, the clique is a young man's comfort and a war zone all in one. While some still engage in small-scale drug trafficking, most lack the operational coherence of their predecessors. One member might sell Xanax or Adderall pills sourced through a cousin in northwest Indiana. Another might flip a few grams of heroin cut with fentanyl from a contact on the south side. There's no centralized profit, sharing, or coordinated territory management, just hustling for subsistence and the occasional splurge on shoes or jewelry. What defines these cliques now is not economic ambition, but the obsessive pursuit of clout, status, and notoriety earned through acts of violence and their online echo. A teenager becomes known not by the money he earns, but by the bodies he allegedly drops, the diss tracks he releases, or the viral posts he makes mocking dead rivals. Retaliatory shootings are often triggered not by business disputes, but by Instagram comments, Facebook live streams, or YouTube videos featuring local drill rappers boasting about real murders in coded language. There is no buffer between the street and the screen. Violence plays out in real time. The strategy of organizational prosecution had a logical premise: decapitate the leadership, and the body collapses. For a while, it worked. The upper echelons of Chicago's most notorious gangs were removed from the streets, and many received life sentences. But over time, that strategy's limitations became apparent. The removal of the head did not kill the snake of violence itself. Today, violent crime in Chicago is not concentrated in a few powerful gangs, but is diffused across hundreds of micro-crews, many of them no older than the teenagers who run them. This decentralization has made traditional law enforcement methods far less effective. There are fewer big fish to fry, fewer criminal conspiracies to penetrate, and fewer informants who even understand the structure well enough to testify about it. Each block, each housing complex, each corner store now plays host to its own localized ecosystem of violence. These aren't turf wars in the old sense. These are retaliatory ambushes, drive-by shootings, and senseless crossfire incidents, often involving children, elderly bystanders, or people entirely unaffiliated with street life. It's no longer possible to make sweeping arrests that disrupt a gang's ability to operate. The violence is too scattered, the motives too personal, and the actors too impulsive. If the 1990s offered a target-rich environment for prosecutors looking to build sweeping indictments, the modern era presents a chaos of disconnected violence, harder to see, harder to stop, and nearly impossible to solve wholesale. The demolition of public housing projects in the 2000s, once hailed as a step toward urban renewal, also played a role in gang decentralization. When massive structures like the Cabrini Green Towers and the Robert Taylor homes were torn down, the residents were scattered across the city through voucher programs and relocation plans. But the tight geographic control gangs once held over these housing developments was shattered in the process. Gang members who had once operated within a vertical command structure now found themselves in new neighborhoods with weaker allegiances and fewer seasoned mentors. The violence that once stayed clustered around single blocks began to spill outward, infecting areas that had never previously experienced such conflict. Without physical territory to guard, crews became more fluid, more transient, and more volatile. In many ways, the city's attempt to break up the gangs also broke the very boundaries that once helped contain their violence. The fragmentation of gangs and the rise of clout culture have also contributed to a surge in indiscriminate, gratuitous violence, most notably in the form of carjackings, armed robberies, and roving street crews who target random civilians. In the past, street violence in Chicago was confined to specific neighborhoods and rooted in territory disputes or interpersonal retaliation between known rivals. The average person knew not to venture east of Larrabee Street or south of Division, the imaginary demarcation lines of Cabrini Green. Today, that calculus has changed. Many modern cliques treat criminal activity not just as survival or retribution, but as spectacle and sport. Young offenders, some as young as 13 or 14, pile into stolen cars and sweep through the city and its suburbs looking for easy targets. A distracted driver, a woman pumping gas, a person unloading groceries in a quiet cul-de-sac. These aren't turf battles, they're ambushes, executed even in affluent neighborhoods like Lincoln Park, Hyde Park, or Oak Park. Surveillance footage often shows young teens jumping out of vehicles with ski masks and Glocks, demanding keys, phones, and wallets, and speeding off in a car they would soon crash and abandon. The logic of organized crime profit, strategy, control, has been replaced by impulsive groupthink and a thirst for viral infamy. For law enforcement and prosecutors, this shift has made it harder to predict, prevent, or even categorize violence. Chicago's crime map no longer has clear hotspots. In a landscape defined by fractured crews and social media clout, chasing, no block is truly safe anymore. Just lucky. Juvenile crimes. Early in my career as a prosecutor, I was assigned to prosecute juvenile crimes in the Cook County State's Attorney's Office in Chicago. I prosecuted the kids who would, at around age 13 or 14, start carrying guns and posing with them on social media, using them as they got older, and eventually becoming hardened in their late teens, actively warring with their ops in the city, or conducting vicious carjackings and armed robberies of innocent people. First, a word about how the system works is necessary. In juvenile court, most cases are decided by a judge rather than a jury. This distinction has significant implications. While adult defendants have a constitutional right to a jury trial, juvenile proceedings are typically bench trials, where the judge serves as the sole fact finder. Judges are guided not only by the law, but also by the statutory mandate to prioritize rehabilitation in juvenile cases. This often results in decisions that reflect a broader focus on a young person's potential for reform, rather than purely on punitive measures. But in cases where a kid acts in shocking, violent ways, causing great harm to victims, it can feel like this system designed to handle them so tenderly is simply inviting them to continue on the same violent path. In practice, some judges appeared willing to give considerable weight to defenses that I believed were not strongly supported by the evidence. In certain cases, this led to findings of not guilty, even when the evidence of guilt was substantial. The rationale, it seemed, was rooted in the hope that a lenient outcome would motivate the minor to change course, a belief sometimes expressed directly to the juvenile in parting remarks intended to inspire rather than deter. From a prosecutor's standpoint, this approach could be frustrating, particularly in cases involving serious violence. It often felt as though accountability was being deferred, even in the face of strong evidence meeting the legal standard of proof beyond a reasonable doubt. And even when the minor was found guilty of very serious crimes, they were most commonly given probation instead of any time in custody. While probation can be appropriate in many cases, in others it can feel insufficient, particularly when the offense is severe. In those instances, the outcome may raise difficult questions about the balance between rehabilitation and accountability, and about what truly deters recidivism in young offenders. The young men I prosecuted in the state juvenile court system were charged with Illinois state crimes, which included weapons, possession offenses, armed robbery, carjacking, sexual assault, battery of school officials, and more. Many of the kids possessing guns were doing it because others around them do it. It's trendy to pack heat. These cases were the most common, but the least interesting. Usually the kids were caught during a traffic stop, and officers would see the gun bulging out from their waistband. Nothing complicated. These do not make for interesting facts, so I will spare you their retelling. I will share with you the cases of the kids who actually, prior to their 18th birthday, committed daring, violent crimes. Names, locations, and other facts have been changed to preserve the privacy of all involved. Kevin's story is tragic and terrifying, but riveting. Kevin's life of crime started before he turned 10. In the span of a few years, Kevin was in and out of the juvenile detention center, battling new cases every few weeks as a preteen. His offenses ranged from firearms possession to carjacking. Kevin did not know his parents, who had died or long ago abandoned him. He lived with other family members who did not keep tabs on him. Kevin idolized older kids in his neighborhood who had entered the gang life. He was sucked in by the allure of belonging to a family. Unfortunately, for Kevin's many victims, this makeshift family was united by a desire to scare the living daylights out of people and rob them of their belongings and vehicles. This was Kevin's way of life for a long time. I remember talking to a Chicago police detective who worked for the city-wide carjacking task force. He told me, Kevin is 11 years old and already has legend status in the police department. We arrested him the other day for the millionth time. You know what he had on him? A loaded gun, a Cuban cigar, and Trojan condoms. He said he was holding them for his cousin. Boy, do I hope that shit is true. The detective showed me pictures of Kevin riding through an intersection in the driver's seat of a stolen car, wearing sunglasses, smiling ear to ear, holding a Black and Mild in his fingers while gripping a pistol with the same hand. Kevin did not, by the way, look older than his age. He looked exactly how you'd expect an 11-year-old to look. The detective informed me that a while back he carried out a search warrant on Kevin's bedroom, located in the house of the relative with whom he was living at that time. The police found, under Kevin's bed, 20 key fobs from stolen cars. Another officer who had arrested Kevin told me that he had asked, Kevin, why do you do this? In reply, Kevin asked, have you seen the movie Cars? Yes, replied the officer. I want to be just like Lightning McQueen, he said, laughing. Many think this moment reveals the true youth and immaturity of Kevin. I, however, think he was being facetious, showing self-awareness through the insanity of his statement. As young as he was, he seems to have understood the irony as much as anyone. People in my division, also young prosecutors, got a kick out of Kevin, imagining a kid of that age demanding someone's wallet in his high-pitched voice. A criminal mastermind who hadn't even begun puberty. But we also recognized the tragedy in his life. The kid's parents had both totally failed him, and he had no chance at a normal life. This brings us to a question without an easy answer. What do you do with a kid like this? Locking him up keeps society safe from him. He was a clear danger to the city of Chicago, robbing and carjacking countless people, causing them physical harm and mental distress. It is harrowing to be carjacked at gunpoint, even if the perp is a child. But we also recognize that putting an 11-year-old with hardened 17-year-olds in juvenile jail would only make him worse. Ultimately, he needed to be held in custody, with the juvenile jail center providing special housing for him where he would not be intermingling with dangerous older kids. Or he needed some other option where he would be confined, but also rehabilitated. But the judge opted for a different path. Each time he committed a new crime, he was released to children's homes and to foster parents, and he would run within days of being placed there, with no one able to stop him from leaving. Over the course of Kevin's many cases, the judge repeatedly ordered his release, unable to fathom placing him with older kids in custody, where he could be hurt or influenced in an even worse direction. But each time he was placed in a new foster or group home setting, Kevin would leave the placement without permission and quickly reoffend. In one instance, he left a group home the same day that he was placed there and, not far from the home, carjacked someone. He put his finger under his shirt and pretended it was a gun. He then drove the stolen car 20 miles back to his neighborhood and reunited with his crew. Initially, I argued to the judge that Kevin posed a significant risk to the public, but that argument was consistently met with skepticism due to his young age. Over time, I shifted my approach and began expressing concern for Kevin's own safety. I mentioned the possibility of Kevin attempting a robbery on someone who was legally armed, which could result in dire consequences. That concern received little traction. Then, one morning before court, news broke of an unidentified juvenile Kevin's age being shot during an attempted carjacking by a concealed carry holder. The courtroom was filled with unease, and the judge appeared visibly shaken. Everyone thought it was Kevin. We waited around all morning to find out if it was him. Ultimately, it was not him. The judge was doubtlessly relieved, knowing she dodged a bullet. Not long after, when Kevin was again brought in on new charges, the judge made a decision that I know was difficult for her. Kevin was ordered to remain in a secure, locked youth facility designed for minors whose repeated offenses suggested they needed more structure than traditional foster care could provide, but less brutal conditions. I do not know if Kevin is still there, but I know that if there is a way to escape, he found it. Carjacking the police. On one Sunday, Kevin and his band of merry carjackers had strayed westward from their neighborhood in the south side of Chicago into a neighborhood where a lot of police officers and firefighters lived. They drove into the parking lot of a grocery store, looking to carjack an unsuspecting victim. It did not take them long to find their target. They found a middle-aged black woman dressed in a Chicago Bears jersey, with her stylish but oversized sunglasses pinned up on top of her head. The crew, which included 4 teens, caught her while she was loading groceries into her SUV. The woman had just wrapped up a grocery trip in preparation for hosting a game watch party for the Bears in her nearby home. She had in her cart hundreds of dollars worth of food and drinks, from buffalo chicken dip to glass beer bottles. The boys surrounded her. Kevin yelled out, "Bitch, give us the keys," pointing the gun at her face. Though it was overkill, the rest of the crew also had guns pointed at her. The woman froze in astonishment, struggling to process what was happening around her. Within a few seconds, as the fear swept through her, she understood what was going on. She managed to dig into her pocket and pull out her keys. One of the boys snatched them from her, and they began gleefully hopping in her car one by one. The final carjacker grabbed her shopping cart full of food and forcibly threw it to the ground, shattering bottles and splattering the asphalt with onion dip and salsa. What the carjackers did not know was that their victim, the woman, was an off-duty police officer. She had investigated crime for decades, but had never been victimized in her personal life. Despite her the job desensitization to the horrors of crime in Chicago, she was completely rattled. In a moment of fear and panic, she pulled out her firearm and shot it in the air in an attempt to scare the carjackers out of her car. It did not work, and they sped off in her SUV. The off-duty officer was charged by the state's attorney's office, NY Employer, Adult Criminal Division, with felony reckless discharge of a firearm. While her decision to fire her gun as the kids drove off was perhaps unwise, as she could have hit a bystander, and the kids were already getting away, I think sympathy was in order for this woman. She had just had her car stolen from her, and her judgment was clouded due to being suddenly and unceremoniously victimized. I thought it would be appropriate to use our prosecutorial discretion and let a crime victim off without felony charges that would ruin her career, and to focus on the offenders who caused all of this. But the office decided that her firing off shots in a crowded parking lot was dangerous and reckless, especially given her training as a police officer, so they charged her. The local news media ran stories about the officer, highlighting civilian complaints made by people she arrested over the course of her career, painting her as the villain in the story. Having reviewed thousands of pages of officer disciplinary records during my time as a prosecutor, I came to realize that the overwhelming majority of complaints lodged against officers were ultimately unsubstantiated. A small percentage involved lapses in judgment that merited disciplinary review, and sometimes serious misconduct. The case of this off-duty officer underscored a recurring theme I saw in the criminal justice system in Chicago outcomes, sometimes appeared to defy common expectations, where the result was the opposite of what you'd think should happen. I found myself privately referring to this phenomenon with the phrase, "Every day is opposite day." Consider the perspective of a veteran police officer. After years of confronting volatile and dangerous situations, the officer is suddenly the victim of a crime, targeted by a group of armed carjackers, while off-duty. In response, she makes a split-second decision to use her service weapon in an unwise, but ultimately harmless manner. Instead of being treated as a victim, or at worst being suspended or fired, she is charged with a felony, which could land her in prison for many years. In the meantime, the individuals who committed the carjacking, juveniles, would almost certainly receive probation rather than prison sentences if they were ever even caught. That outcome left many of us in the courtroom, struggling to reconcile it with our understanding of fairness. It was one of many moments highlighting the deep complexity of pursuing justice in a system tasked with balancing accountability and rehabilitation. Often, I found myself questioning how exactly the decision-makers in the system went about performing this balancing act. The results never seemed so balanced to me. As was often the case, the tide came in, the tide went out, and the wind blew, but my convictions moored me firmly in place, unmoved, but at odds with the bizarre situations unfolding around me. The officer's criminal charges were relevant to me for a key reason. Her car was seen driving around a few hours later in the heart of downtown Chicago. When it was cornered by police, the kids running from the vehicle, including Kevin, were caught. I prosecuted the case in juvenile court. In the case against Kevin and his friends, I needed the officer as a witness to testify that her car had, in fact, been stolen that day, so we could prove our charge that because they do not want retaliation against them, or they do not like the kids were riding in a stolen vehicle. But why would she help me, a prosecutor, by being a witness against the carjackers, when my office's adult division was prosecuting her for firing her gun recklessly? We could subpoena her to the witness stand, but she could invoke her right to remain silent, stating that any comment she would make about the case could incriminate her on her own pending case. She could make my job of proving the case against the juveniles difficult. If I could not establish that her car had been stolen by the defendants, I could not prove they had done anything wrong by riding in it. To my surprise, the officer ended up cooperating with me and testifying. It took some tactful convincing at first. I very carefully explained what I would and would not be asking her. I promised her I would only be asking about the fact that her car was stolen, as I needed that fact to prove the case. I told her that my questioning would be short and sweet. I found that people are much more willing to assist you as a prosecutor if you explain to them the contours of what you're asking them to do, why you're asking them to do it, and how it will likely go down. This generally puts people at ease. A lot of attorneys think it suffices to say, "You've been subpoenaed. You really don't have a choice here." Public speaking. I had experience in these situations explaining to people my straightforward intentions and having them tell their story, delivering them a clear-eyed roadmap of all that would be required of them. This made it easier for the witnesses to feel that everything would ultimately be okay. So this officer came around and was rather easy going about it. As I prepared her for her testimony, she was teary-eyed and distraught, but committed to testifying about the events of that fateful day. She participated in my juvenile trial purely in the spirit of bringing the offenders to justice. I admired this about her. Months later, I found out that she was found not guilty at her trial for reckless discharge of a firearm. The trial in the case was really just the trial of the driver of the car. None of the boys could be charged with the carjacking itself, because the carjackers were all wearing masks when they stole the car, and we could not prove any of the boys caught were on scene at the carjacking. All of the passengers were charged with criminal trespass to vehicle, a criminal charge for a person who rides as a passenger in a vehicle they know is stolen. Criminal trespass to vehicle is a simple misdemeanor offense. We could prove they know it was stolen by the fact that they all ran from the car when police finally cornered them. Kevin and the rest of the passengers pled guilty because they were clearly seen by officers in the car, and they ran from it when officers. Even people with nothing to lose are fearful of testifying, either approached, proving they knew it was stolen. The driver? We'll call him Jason, took us to trial. We charged him with possessing a stolen motor vehicle, which is a felony, unlike the misdemeanor criminal trespass to vehicle offense his friends were prosecuted for. A person possesses a stolen vehicle if he is driving it. So we had to prove Jason was the driver to get him on the felony, the more serious offense. A few hours after it was stolen, the vehicle was located by someone working with Chicago police watching a police observation device, pod, camera. In dense areas, like downtown Chicago, there are pod cameras on every block. They are CPDs, eyes in the sky. One of the most impressive aspects of law enforcement I have witnessed is Chicago police's ability to monitor criminals on camera, give real, time location information to officers on the ground, and get the offenders under arrest. All with efficient communication and decisive action. The pod operator monitoring the camera spotted the stolen vehicle and immediately dispatched nearby officers, giving them updates. The vehicle is traveling east on Washington, now heading north on Dearborn. It's turning west on Lake. This monitoring involves the pod operator switching between multiple street cameras facing different angles to keep eyes on the car. They convey the location information to the officers canvassing the streets, who have to weave in and out of traffic, avoiding turning the wrong way down a one-way street and careening around pedestrians. Slowly but surely, the police converged on the vehicle. After being chased by a flurry of police cars throughout downtown Chicago, Jason stopped the car. The stolen car crashed into another car at the corner of Wells Street and Wacker Drive, right on the south bank of the Chicago River, where it flows east to west through the heart of downtown. Most of the boys flew out of the car and ran in different directions. Some of the boys ran south into the Loop area, the business district. Jason, the driver, fled north over the Wells Street Bridge, which, funny enough, is the place where I had proposed to my wife. To learn how the boys were caught, I watched the body-worn camera footage of the officers who chased the boys down. There was one officer, Officer Moyer, whom I nicknamed Super Cop. The guy looked like he hit the station weight room on his lunch breaks. He sprinted after one of the kids who was a fast runner and caught him several blocks south of where the stolen car had stopped. He spoke in a well-mannered, courteous way to the kid as he gingerly placed the cuffs on him. He handed the kid off to other officers who had lagged behind him but had caught up. Super Cop then sprinted north to the scene of the stolen car, inquiring with the police officers securing the vehicle if there were any offenders who had not been caught yet. They pointed him to the north, giving him the description of the driver, Jason, who had run north over the Wells Street Bridge. Other officers had chased Jason in that direction, but failed to find him. So, Super Cop sprinted over the bridge in the direction of Jason. There was a backup of cars sitting on the bridge that were stuck in a logjam, while police walled off the area. Super Cop's keen eye caught the gaze of someone sitting in his car on the bridge, looking alarmed. Something didn't seem right with this driver. Super Cop looked into the back seat and saw a boy matching the general description of Jason, the driver of the stolen car, but wearing different clothes. Super Cop asked the pod operator to check the footage of this area. Sure enough, Jason had ripped off a sweatshirt while running across the bridge and hopped into the car of an unsuspecting driver. He ordered the kid out of the car and detained him. Once Jason was in cuffs, the guy told police that Jason had jumped into his car, threatened him, and ordered him to drive away. We knew that this kid was Jason. The clothing he had been wearing when he fled the stolen vehicle was found discarded right by where he entered the man's vehicle on the bridge. And cameras in that area showed Jason shedding those clothes. So we had a nearly unbroken chain of events tying Jason to the stolen car. But there remained one issue. Was he the driver? The person possessing the stolen vehicle? Our question was answered by another look at the pod footage. Right as the vehicle came to a stop, the pod camera operator changed the angle of the camera to ensure the vehicle was in frame, and to ensure that the camera was positioned facing the driver's side of the car. Every time a pod camera's angle is adjusted, it takes a few milliseconds for the picture to render in clearly. As luck would have it, the blurriness dissipated right as the driver's side front door was opening, and we could see Jason about a foot away from the driver's door, sprinting off. The driver's side back door was open too, but we could see from other footage that young Kevin and another boy had come running out of that door. Thus, who else could have been the driver but Jason? It was clearly him. We couldn't make out the clothing of the blurry figure coming out of the driver's door for the millisecond where the image was rendering, and the blurry figure was right by the door. But the moment that blurry figure rendered, it was clearly identifiable as Jason based on his clothing and appearance. He couldn't have come from the back seat because Kevin and the other back seat passenger fled from there, and the blurry blob that rendered into Jason clearly came from the driver's door. At first glance, it may seem clear that Jason should have been found guilty of the felony offense of possessing a stolen motor vehicle, being that he could be identified as the driver. But this case serves as an example of the unwritten standard I often witnessed being applied in juvenile court for a minor to be found guilty at trial. The evidence has to be so overwhelming that a finding of not guilty would seem utterly ridiculous. In this case, the judge was not likely to feel that a not guilty was ridiculous, because she could focus on one narrow issue, the identity of the person seen exiting the driver's seat in a blurry surveillance video. Though the image gradually resolved into what was clearly Jason, the judge claimed that the lack of clarity left her with reasonable doubt. From my perspective, the conclusion seemed obvious. The other occupants of the car had all been accounted for and exited from, or were seated by, passenger doors. Jason's figure rendered into frame right beside the open driver's door and was the only one by the driver door. But the judge used the momentary blurriness as a reasonable doubt escape valve. The judge ultimately found him not guilty, and he was released from custody. Moments like this were head-scratching, to say the least. Everyone in the courtroom seemed to know that the defendant was guilty beyond a reasonable doubt. The defense lawyer raised his eyebrows, pleasantly surprised, but not too surprised at the verdict. He wore a wry smile. The judge delivered the not guilty verdict without making any eye contact with me, but she cast a long blank stare towards the back wall of the courtroom. I had to wonder whether the judge was carrying out the legal process in earnest, or whether she was applying principles from a secret tome. Nothing written in the law books, but some book of leniency circulated. Amongst the judges with me, none the wiser. A most violent day. Carjacking police officers may be egregious, but many cases I handled were worse, involving gratuitous, horrific violence. These cases necessitated my best efforts in bringing the offenders to justice. Jerry and his friend, both older teens, already had long rap sheets. Jerry had been found guilty in juvenile court of committing violent carjackings that involved him pointing a gun at people, ordering them out of their cars, stealing the cars, and driving off. In some cases, he had beaten people severely in the process. Jerry and his friend decided to up the ante one beautiful Chicago summer day and go on a spree that would make Bonnie and Clyde look like Simon and Garfunkel. Jerry and his friend committed a carjacking and robberies spanning 3 crime scenes, involving multiple victims. They started without much of a plan, as is commonly the case with young carjackers. It's all about the thrill, so most carjackers troll the streets until they see a defenseless target, and they pounce. They spotted a young couple who were taking groceries into their brick walk up in Chicago. They decided these would be their first victims. Jerry and his friend approached with guns drawn and pointed at the couple, demanding their keys and wallets. The couple was terrified, crying and holding their hands up, showing that they would not fight back. The victims' compliance did not stop Jerry's violence. He and his friend shoved the couple to the ground and kicked them repeatedly before taking their stuff. According to the victims, Jerry and his friend were kicking and mocking them as they landed their blows. They took off in the couple's vehicle, hunting their next victims. Jerry rode up on a young gay couple, parking their car. The men were about to get out and enter their friend's apartment. Ferry and his friend approached and threatened the men with guns and tried to take their car keys and wallets. Unbeknownst to Jerry, these victims were in no mood to cooperate, so they fought like hell, trying to push their attackers away, refusing to give up their property. Unfortunately for these victims, that was a grave mistake. At this point, a frustrated Jerry shifted gears. Jerry and his friend took one of the men's 7-Eleven big gulp cups and shoved the man's face into it until he was gurgling and drowning. Jerry then took an unfinished taquito from the car and threw it at the other victim's face to humiliate him. All of the while, Jerry and his friend were cursing at the men, threatening to kill them if they continued to fight back. To complete the act, Jerry and his friend then took the butts of their pistols and beat both victims on their heads until they were completely unconscious. The men lied motionless on the scorching sidewalk, copiously bleeding. When it was safe, concerned bystanders approached them and called 911. Fortunately, EMS arrived in time to treat them and save their lives. Jerry and his friend sped away and drove around for a few minutes before pulling up on their final victim. He complied immediately, and he was not roughed up as much. The robbers took his wallet, phone, and headphones. The police had already been called by the first victims and a number of other witnesses, so police were on the lookout for the stolen car taken from the first victims. A Chicago police patrol officer fortunately caught sight of the car before the culprits could ditch it. He called for backup, and Chicago police vehicles converged on Jerry and his friend. Before he knew it, Jerry was cornered and placed under arrest. Jerry had many of the victims' possessions in his pockets and near him in the vehicle. He was caught, arrested, and charged by me and my colleagues. You may think this is an open and shut, easy case, given that the suspect was caught near the stolen car with stolen possessions, mere minutes after the crimes were committed. But let me highlight a few obstacles. First of all, the boys were wearing masks. Because of this, none of the victims would be able to identify Jerry and his buddy in a photo lineup. Where officers put pictures of the offenders down on the table with multiple others with similar traits to see if victims can identify the offenders' faces. When a victim can identify an offender's face, it usually makes for great evidence, but it was not possible in our case. Second, none of this was captured on camera. There is an unwritten, unspoken rule creeping its way into the courtroom these days. If something isn't on camera, it did not happen. At least, not beyond a reasonable doubt. Defense attorneys are very skilled at convincing a judge or jury at trial that the crime couldn't have happened the way the government claims. None of this is on camera. We cannot possibly know who was involved. If the real culprits are still out there, there are too many open questions. This tactic is annoying for a prosecutor, but surprisingly effective with juries. Where no part of a crime is captured on camera, prosecutors now deem such a case as weak. In this case, the best we would have is the aftermath, where police officers' body-worn cameras would capture the arrest of Jerry. The third issue is what I like to call the carpool defense. A defense attorney could argue, sure, guys resembling Jerry and his friend robbed and beat people up at 3 crime scenes, and Jerry and his friend were caught in the stolen car used in the crimes. However, Jerry and his friends may have actually entered and started driving the car after their 2 friends of similar race, height, weight, build, and hairstyles handed it off to them after whatever crimes those guys may have committed. The other guys must have just handed over all of the stolen stuff to Jerry, without explaining that it was stolen. He had no clue. At trial, juries have fallen for these far-fetched defenses, even when prosecutors do a good job countering them. But Jerry had, upon his arrest, multiple stolen items in his own pockets from the victims from each crime scene. So I believed that the simplest deductive reasoning would force a guilty verdict in this case. Jerry had Colonel Mustard's AirPods in his coat pocket, Mrs. Peacock's wallet in his pants, Professor Plum's iPhone on his lap in the car. The judge would have to indulge too many defense, lawyer what-ifs, to find the kid not guilty. The judge would have no choice but to find him guilty, even in spite of the usual defense theories. Prior to Jerry either pleading guilty or demanding trial, we had to litigate a different issue, an issue which would determine how severe Jerry's consequences would be. The issue was whether Jerry would be considered a violent juvenile offender under the law. The violent juvenile offender law ties the judge's hands and forces the judge to send the kid to juvenile prison if the kid is found to be a violent juvenile offender. Going to juvenile prison was a big deal, because in almost every case we handled, the judge would just give the kid probation, which means that instead of going to prison, a kid goes home, and a probation officer checks in with the kid every so often to make sure he's behaving. The violent juvenile offender law was thus a great tool to hand the most dangerous repeat offenders a real lesson in accountability and to protect the public. Under the law, a kid is a violent juvenile offender if he was previously adjudicated a delinquent minor or found guilty of specific violent crimes prior to committing the latest crime. A judge adjudicates when she formally decides something. A delinquent minor is a minor guilty of committing a crime. Therefore, a minor is adjudicated a delinquent minor at the moment when a judge decides the minor committed a crime, either when the minor pleads guilty and admits it to the judge, or when the judge finds him guilty at a trial. In summary, if a minor is found guilty of certain violent crimes and he later commits a new crime, then in the new case he is considered a violent juvenile offender and he must get prison time. Here is a bare bones example of how it works, so you can understand the issue in Jerry's case. Imagine on January 1st, 2024, Timmy commits an armed robbery of someone on a sidewalk. He is caught the same day and charged in court. On April 1st, 2024, after consulting with his attorney, he pleads guilty in court. On April 1st, 2024, he is thus adjudicated a delinquent minor. Then while on probation, on July 1st, 2024, Timmy commits a carjacking. For this new carjacking case, Timmy has previously, on the 1st of April, been adjudicated delinquent or found guilty. So once he is found guilty by plea or trial, the violent juvenile offender law would apply, and he must go to prison in the second case. In Jerry's case, if before the present carjacking and robbery spree, Jerry had been found guilty of a violent crime, he would be a violent juvenile offender in his new case, and he would be required to spend some time behind bars. Jerry had, in fact, been found guilty of a qualifying violent crime, carjacking, prior to committing the crime spree. He had pled guilty, and thus had been adjudicated a delinquent minor prior to the new crime. So the law should have applied to him, but not so fast. The public defenders had come up with a clever new argument which had some merit to it, and would free Jerry and others in his shoes from being considered violent juvenile offenders. The public defenders argued that a minor is not adjudicated a delinquent minor until he is sentenced for the previous crime. Jerry had pled guilty to the prior carjacking case, but he had not been sentenced yet. Sentencing often took place a few weeks or months after the guilty plea or trial. So under their view, he was not adjudicated delinquent yet, and the law did not apply. If a minor is not adjudicated a delinquent minor until sentencing, and the new crime spree happens post, guilty but pre-sentencing, then the violent juvenile offender law would not apply. Many of the judges adopted and applied this view. We had many cases where kids would commit crime after crime after crime, and because of their repeat offending, their public defenders knew the kid would be deemed a violent juvenile offender for the next case if any prior case proceeded to sentencing, which would mean prison. So the public defenders had every reason to delay sentencing to push off the moment that a minor formally became a violent juvenile offender in the eyes of a judge who now viewed sentencing as the key moment a kid became a VJO. This distinction created a window of opportunity. If a juvenile committed another violent offense in that time between the plea and the sentencing for the first crime, the defense could argue that the VJO law didn't apply, because the minor hadn't yet been formally adjudicated by being sentenced on his first case. Many judges came to accept this interpretation. It let a lot of juveniles off the hook. Thus, despite committing and pleading guilty to crimes in the past, Jerry may not be a VJO after all, and may never face prison time. This became the standard argument for the public defenders in all such cases. The public defender's argument pulled in an established concept from adult criminal court. When an adult criminal's prior conviction is used to enhance a present pending crime, the prior conviction can only count for enhancing a later crime once sentencing has occurred on the first crime. The public defenders argued the juvenile court should work the same way, but their interpretation defied the clear writing of the juvenile law. Delinquent minor means a minor found guilty of a crime, and adjudicated means decided. The judge decides that a minor is guilty when she finds them guilty at trial or accepts their guilty plea. The appellate courts also, across many cases, found that a minor is adjudicated delinquent when he pleads guilty, confirming the common sense, plain reading of the law. But the judge in Jerry's case found, after extensive arguments and written briefings by both sides, that a minor is adjudicated delinquent only upon sentencing. And because Jerry had not been sentenced for his prior crimes yet, he would not be a VJO and would likely face no prison time for this violent crime spree. I drafted a lengthy memo to my supervisors advocating for our office to pursue an appeal in this case, believing the legal issue warranted further review. However, the decision ultimately rested with leadership, and my request was denied, though they were very complimentary about how hard I fought. While I didn't agree with the outcome, I appreciated leadership's acknowledgement of the effort and commitment I had shown throughout the case. They gave me a kindly pat on the back, which I would have traded every day, and twice on Tuesday, for giving me the green light to appeal and continue the fight. I graduated to federal prosecution shortly after this decision, so I do not know what happened in Jerry's case. I can only hope he learned some deterrent lesson that would prevent him from creating more crime victims, though I am quite skeptical. Jerry's offense was deeply disturbing and unprovoked and violent attack on innocent individuals. The carjacking appeared to have little practical purpose. The stolen vehicle was quickly abandoned, and only a small amount of money was taken. This pattern was common in juvenile cases. Often, young offenders would leave stolen cars or belongings behind shortly after taking them, even when there was no police pursuit. This raised a persistent question. Why commit such crimes with little financial gain and no clear plan? In my experience, many of these acts were driven by boredom and a desire for the adrenaline rush associated with asserting dominance rather than material profit. These youths are often influenced by a street culture that valorizes toughness and fearlessness. I still vividly remember interviewing one of Ferry's victims. As he recounted the incident how Ferry nearly drowned him in his own big gulp and then beat him unconscious, he broke down in tears. The emotional trauma was overwhelming and lasting, a stark reminder of the real human cost behind these cases. A city in turmoil. The residents of Chicago are tired, and they feel that the violence is unrelenting. A detective assigned to the citywide carjacking task force once told me that more than half of all carjackings in Chicago are committed by boys under the age of 18. Teenagers shouldn't be capable of such cruelty. It is harrowing and tragic for all involved that teenagers could exact such violence. The stories of Jerry, Kevin, and Jason only scratch the surface. Other cases left me equally stunned. One summer evening, a pregnant woman was returning home to her brownstone in a Chicago neighborhood. She approached her garage in her vehicle through the alleyway behind her house, not knowing what awaited her. She had likely taken this same path hundreds of times with no issues. But as she pulled into her garage, two teenagers in dark clothing and face masks emerged from the shadows of the alley. They pointed guns at her and threatened to kill her if she didn't comply. They stole her keys, took her vehicle, and drove off, leaving her standing alone, shaken, and terrified. The physical financial loss was secondary to the psychological trauma. As a single mother living in a high-crime area, she now had to worry not just about her own safety, but about the safety of her unborn child. She had to consider whether reporting the crime would bring further danger to her. This woman was so traumatized and stressed that she feared having a miscarriage. Like many other victims I've spoken with, she was left with deep psychological scars. Many victims develop severe anxiety, require therapy or psychiatric care, and are haunted by fear long after the incident is over. Another case that stuck with me involved a man in his late 70s. He was driving a route from his home in the northern suburbs of Chicago, down through the city, and into Indiana to visit relatives. He was driving late at night, simply following Google Maps. Unaware that he had entered a dangerous area on the south side, he stopped to refuel his car. As he pumped gas, a group of masked teenagers, lying in wait for an easy target, like an elderly man, descended on him. Their intent was to rob him as violently as possible. One offender grabbed the gas nozzle from his hand and held the man up with the other hand, beating him repeatedly in the head and face with a metal nozzle. The man collapsed, bleeding, and fell unconscious. The attackers stole his car and sped off. The minor who carried out the assault was later caught. At his initial hearing, the judge ordered him held in custody pending trial. I spoke with the victim afterward. Despite what he had endured, he expressed nothing but sympathy for the teenagers who attacked him. He told me he pitied them, imagining the despair and brokenness that must have led them to such violence. Then he made a remarkable request. He wanted to see his attacker receive a lighter sentence, but only if the young man agreed to meet with him weekly for a few months. The victim hoped to explain the harm that had been done, and, as a devout Christian, to guide him toward a better path through faith. I shared this offer with the public defender, already anticipating the response. Without hesitation, she replied, "I don't think my client would be interested in that. Child abuse and neglect." In the Cook County State's Attorney's Office, young prosecutors do rotations in several different divisions to gain diverse experience. The Child Protection Division, which handles child abuse and neglect cases, is located in the same building as the Juvenile Crimes Division. This job was governmental civil law. The legal result of the proceedings was not to imprison anyone, but to temporarily or permanently take away parents' custody over their children until they changed course from their abusive ways. Unfortunately, many parents never learned their lessons and carried on their harmful practices. They would find themselves back in child protection court repeatedly until their parental rights were finally terminated. Some of the young prosecutors in the office, like me, were assigned to do a stint in this joint. The Child Protection Division, it turns out, faces a steep hill to climb in tackling societal problems, same as with all other prosecutorial roles I've worked in. This is not pessimism, but a sober realization derived from the experience of working there. But this unit stands alone in one major way: the people who work in. This division never tire in the battle to do the right thing. The prosecutors who work there fight as hard as you can imagine to make sure the children who come into this system are removed from unsafe environments, and they do it with gigantic caseloads. Other key players in the system, the attorneys from the Office of the Public Guardian, work closely with the kids and zealously advocate for their best interests in court as the children's appointed counsel. I was impressed by them as well. I was further impressed by the public defenders in this division, who provided an invaluable service, advising the parents to take the proper remedial steps to show the judge that they were ready to regain custody of their children. The public defenders advocated fervently in court for the parents, which I know was challenging. But it was well-deserved in cases where a parent's child was removed from their care through no intentional actions of the parent, but solely through lack of ability to handle a kid's complex medical needs or through cognitive limitations of the parent. In the child protection courtrooms, the judges made admirable, balanced decisions across the board in my cases. They had tempers, idiosyncrasies, and the occasional bizarre decisions, but they were fair overall. These judges had the safety of innocent children at the fore of their minds. Plus, the Office of the Public Guardian sometimes took cases to the news media, which meant that judges had to fear negative press in cases where they may have otherwise been inclined to be lenient and send a kid back to a dangerous home where her life could be threatened. Through a variety of forces, sensible results were often achieved. Parents who refused to change lost their kids, and parents who made serious efforts to improve their harmful ways were reunited with their children. Despite all of my compliments of the dutiful public servants working in the division, this unit had no ability to resolve childhood abuse and trauma writ large in this city. Child abuse is occurring on too large a scale for a unit of around 20 lawyers to make a noticeable difference, even with massive caseloads. The cases each started from anonymous tipsters calling the Department of Children and Family Services, DCFS, and anonymously reporting abuse or neglect of children. DCFS would visit the home, and sometimes, if the situation was easily fixable, the case was resolved short of coming into court and answering to the judge. In cases of severe problems where the parents would not fix their harm-causing behavior, the case would come to court for a judge to decide whether the kids were abused or neglected. I am certain that thousands of children in Chicago are living in abusive and neglectful environments, but do not at present have someone willing to call DCFS on the parents. I believe this because many anonymous tipsters often only notice signs of abuse by sheer chance, and the kids could have just as likely continued being abused. With DCFS and the Child Protection Unit, none the wiser. To understand the scale of the child abuse problem in a city like Chicago, take a look at the numbers. Yearly, there are 231,500 calls to the Child Abuse and Neglect Hotline in Illinois. Cook County, home to Chicago, has around 5 million residents, with the rest of the state having around 7 million. Even if Chicago has only a fraction of the 231,500 anonymous tips, and even if only a fraction of them are reporting legitimate abuse, there would still be far too many cases for the child protection courtrooms to handle. So the cases that would make it all the way to the courtroom were the worst of the worst. And even then, only a small slice of the horrors befalling children in Chicago. Neglectful home environments. Our court system's most common types of case involved a neglectful home environment, where the neglect of kids led to psychological issues rather than physical injuries. These were usually cases of women who were severely beaten by their boyfriends and husbands in front of their children. We had hundreds of these cases come in every year. It was heartbreaking to see mothers, themselves victimized, temporarily lose custody of their children for this reason. But kids witnessing the physical abuse of their mother suffer severe psychological trauma. They are much more likely to become abusers, even if it meant a daunting breakup. This woman would not part with or victims of domestic violence one day themselves. Once an anonymous tipster informed DCFS that kids were in a home with domestic violence, DCFS would visit, speak with the mother, and give her several chances to have the guy move out, or to keep the kids away from him before they sought a court order taking her kids away. The court then only became involved where the mom refused to kick the abusive man out of her life after being given many chances. I recall far too many cases where mothers were beaten until bleeding by their abusive boyfriends, their horrified children watching with wide, teary eyes. In one such case, around December in the south side of Chicago, a mother and her boyfriend had been arguing throughout the day. Her 5 children, spanning from 3 years old to 15 years old, looked on, sadly accustomed to verbal and physical abuse in the home. Lately, the mom's new boyfriend had been brutal, but through the eyes of these kids, he was not the first to treat their mother this way. The mom walked away from an argument to take a shower. Her boyfriend had been fuming. As she got out of the shower, the boyfriend grabbed a small Christmas tree from the living room and began beating the mother with it. He then threw her out, naked, into the snow, wearing only her shower cap. Her kids witnessed the whole thing. Unlike most mothers, who did anything to get their kids back, the man, who was abusive and a hardened gang member. In court, she was vituperative towards the public guardian, me, and the judge. At her trial, she denied ever having been abused in front of the kids, despite credible witness testimony to the contrary. This woman was not the common case. Most women admit to the abuse and slowly come around to ousting the violent boyfriend for the sake of the kids. This mom doubled down with a vengeance. So the defense's typical argument, that the mother is also a victim, did not work in this case. After we won at trial, proving the woman kept a neglectful environment by having an abuser around, DCFS made a plan for the woman to get her kids back, stay away from the abuser, take some parenting classes, go to therapy, and so on. But the woman continually fought DCFS at every turn, giving them trouble about attending the requisite classes and booting the boyfriend from her house. Instead of getting her kids back in a few months, her case languished for over a year. In this time, the efforts of a hard-working DCFS worker uncovered a harrowing secret lurking behind the doors of the mom's house. Having built rapport with the two teenage daughters of the family, the DCFS worker learned from them that the mother had sold them for sex to men in the neighborhood. This was brought to the judge, who put the case on a path towards terminating the mothers, parental rights, and getting the kids permanently into safe homes away from the mother and her boyfriend. Sometimes things are actually worse than they seem. Here, as often in this unit, I reflected on how easily this abuse could have been missed. And again, I was haunted by the knowledge that tens of thousands of abused kids will never be saved. Another common case involved parents leaving their young kids home alone for extended periods. I'm not talking about leaving teenagers, or even 12-year-olds at home, nor am I talking about periods of 2 or 3 hours. I had a case where the oldest kid left alone was 10 years old, and she was home alone with siblings ranging from newborn to 8 years old, 6 kids in total. The mother would leave them alone every day for over 8 hours. What's worse, they were squatting in an apartment that the mother had been evicted from. One day, some of the young ones had climbed out of the first-floor window and were running around in the yard in Pampers. A concerned passerby noticed this, followed the tots into the house, and discovered the 10-year-old feeding the 6-month-old a bottle in the basement, with the other kids running around in underwear. Oddly enough, only several of the kids even belonged to the mother of the case. Many of them had other mothers and fathers who had abandoned them with this woman. On one hand, this woman must have had a big heart to take responsibility for children who were not hers and not even related to her. But, on the other hand, she had left the kids to fend for themselves for the entire workday. Further complicating things, she felt as though she had to work to get money to feed the kids and had not saved up enough to pay for daycare. Such is the strange complexity of life in Chicago. Fortunately, none of the kids from that case were physically harmed in any way. And by the end of the case, the mother had been provided resources to aid her in getting the older kids into public school and getting financial aid for daycare. Everyone in the room was satisfied that this mother had learned to never leave her kids alone again. Everyone but me, who couldn't help but feel some lingering doubts. It may sound cynical, but what some call cynicism, others call realism. It's a crazy, difficult world out there, and I feel no need to lie to myself about that fact. Not all home alone stories ended well in another case. A family living in the west side of Chicago had left their young kids home alone for a few hours. There were 4 kids in this case, who were something like 3, 5, 8, and 11. The 11-year-old found the father's gun, which was not well hidden, and he started to play with it. Unbeknownst to him, the gun was loaded. So when he pointed it at his 3-year-old brother and pulled the trigger, the unthinkable happened. The 3-year-old did not survive. As you can imagine, the family was irrevocably broken. D, F, and the child protection unit may otherwise not have been involved. After all, this could be chalked up to a terrible accident and a painful lesson in proper gun storage. But the reachability of a loaded gun was not the only thing making this a neglectful environment. When police arrived on scene, they found crack pipes on the ground, plus syringes and narcotics also within reach of the children. This necessitated the court becoming involved and, indeed, removing the children from the home on a temporary basis, pending the parents proving that they were capable of a major course, correction. Physical abuse. The cases of intentional physical abuse were some of the most depressing and the hardest to prove at trial. These cases came to court when a concerned grandparent, teacher, or doctor saw bruises or abrasions on a kid. The cases where the kids were of speaking age were not as challenging to prove at trial, because often, after a delicately conducted private interview, kids would reveal that their father, mother, or step-parent beat them or sexually abused them. We would use the interview as our main evidence at trial. In many cases, the kids were not of the age where they could verbalize what was going on in the home. Thus, we would not have any direct witnesses to the abuse. The parents would often refuse to answer questions about where the kids' injuries came from, or they would lie about how the injury happened. Injuries themselves tell a story, and usually the story they tell contradicts the lies spun by the abusive mother or father. For example, a doctor can discern the relative ages of bruises. If a kid is covered in bruises, but based on their colors, The bruises are of different ages. It shows that a kid has received beatings many times the past few weeks. This contradicts the common story. It must have been the neighbor boy playing rough yesterday. In even more serious cases, kids would have broken bones. Where parents had explanations for the injury inconsistent with the type of bone fracture, abuse could be inferred by pediatric doctors. For example, some leg bone fractures are consistent with a baby being shaken, and others are consistent with a baby being dropped. Often, an abusive parent would realize that their abuse went too far and that their child was seriously injured. So they would bring the child to the hospital and provide an explanation such as, "The dog bumped into me, and I dropped him." This would be a giant red flag to doctors, who could tell that the fractures were not caused by the dropping of child. The case of Paris. My first child abuse trial occurred early in my time in the Child Protection Unit. Trials would only happen when the parents did not plead guilty, called stipulating in this division to committing the harms they were accused of committing. Paris parents came under scrutiny when a hospital social worker called the DCFS tip line on them. The parents brought Paris, their newborn girl, into the hospital with fractured legs and ribs. They had no good explanation for how the baby got so injured. The mom said that on Saturday morning, 1-month-old Paris' leg looked very swollen and she was crying non-stop, so she took the baby to the hospital. The mom said that she had been taking care of Paris for the last few days, other than the day prior, when the father was alone with Paris for a short time. The father was interviewed, and according to the DCFS investigator, he was nervous and evasive. His story also contradicted the mother's story, plus his story kept changing, as he had trouble stating whether and for how long he cared for the baby over the past few days. Eventually, he offered a half-hearted explanation that he fell asleep with the baby on the bed and woke up with the baby between his arm and the wall. This was the only explanation either parent offered for the injuries, and the father offered it only after being questioned at length. It is unimaginable that a baby could have had multiple broken bones from this. The parents also denied that anyone else had watched the baby recently, ruling out that a relative or friend could have caused the injuries. The pediatric doctors, seeing that the baby had multiple fractures in her ribs and legs, concluded that the father's story did not account for the injuries, and that severe. The hospital called in its child abuse pediatrics team to provide a consultation. This CAP team, made up of pediatric doctors who specialize in identifying child abuse, conducted a detailed analysis. They examined X-rays, all prior treatment records, birth records, as well as the notes of interviews given by parents. Their ultimate goal was to determine if child abuse occurred so that appropriate decisions on how to treat the child could be made, and DCFS could become involved if necessary. The CAP team concluded that this was a case of child abuse for the following reasons. First of all, the baby had several bucket handle fractures in each leg, in her tibiae and femurs. Bucket handle fractures are commonly created by shaking, pulling, or twisting a baby's limbs. The vast majority of pediatric doctors believe that these fractures, absent a good explanation, are by default indicative of child abuse because of the type of force required to cause them, forces no child would naturally experience naturally. Next, the baby also had fractures of the posterior ribs. These fractures were also bilateral, or found on both sides of the baby's body. This was consistent with a person holding a baby around the rib cage and squeezing with force, breaking the ribs in the location where they stretch around to the baby's back. The fractures being present bilaterally was also suspicious. The odds are very low that an accidental drop or rough handling would result in fractures that mirror each other on each side. It's much more common that such bilateral injuries are caused by someone grabbing a baby with both hands on both sides of her body and shaking, squeezing, or otherwise abusing her with both hands. The doctors ruled out alternative explanations for the injuries. They examined whether the baby's bones were weak, such that fractures could have happened without excessive, abusive force. Paris did have low vitamin D levels, and low vitamin D can lead to rickets, which is the softening of the bones. However, a large percentage of babies have low vitamin D levels, and there are other methods that can be used to discover if a baby has rickets or soft bones. Paris, as it turns out, did not have rickets. She had healthy bones. As you'll hear time and again in this book, despite the strength of the case, this was far from open and shut. The public defender on the case was a clever guy and a conscientious attorney who fought like hell for his clients. We became pals during our time in this unit, regularly facing off against each other. I knew he would pull out all of the stops. He hired a doctor notorious for testifying for the defense in our building, and zealously arguing that the child abuse doctors got it all wrong, and that the injuries were not evidence of child abuse. This doctor, whom I'll call Dr. Richardson, struck fear in the hearts of the prosecutors in my division. He would often dance circles around them, poking holes in the methods and conclusions of the pediatric and child abuse doctors, claiming that the parents' explanations fit the injuries better than the conclusions of the treating doctors. He was a practicing doctor by day, but in the courtroom, he was a paid expert, a hired gun. His every word was designed to convince a judge that the parents did not abuse their kid. Our experts were simply the doctors who treated and examined the baby, with no profit motive. Our experts were often too busy to prepare for trial with us in any meaningful way. At trial, their objective, straightforward testimony would often fail to move the judge in the same way as Dr. Richardson's compelling song and dance. We did not have the budget for paid experts to go blow for blow with Dr. Richardson in a battle of the experts. It further helped the defense case that Dr. Richardson had a top-rate education. He graduated at the top of his class for college and medical school and completed a prestigious residency. The doctor's success in getting abusive parents out of trouble, combined with his distinguished background, created in him an unyielding pride. Hubris, like any weakness, can be exploited. I planned my attack accordingly. Dr. Richardson reviewed the medical records and reached the conclusion, in his expert report, that Paris' injuries could easily have been caused by the father's body accidentally crushing the baby while in bed. Notably, the doctor unilaterally changed the father's story from, "I woke up with the baby between my arm and the wall," to, "I woke up and I was lying down on top of the baby." The father did not claim this, but the doctor pretended as though he did. He stated that bucket, handle fractures do not necessarily result from things like shaking, twisting, or pulling. Rather, they can basically happen anyhow, including from the type of force exerted by lying down on top of a child. After hearing the hospital's child abuse doctors say that these fractures were indicative of abusive actions like shaking, I did loads of research. Every major study and pediatric medicine publication reached the same conclusion: bucket handle fractures were solid indicators of child abuse, caused by forces that no one should exert on a baby. Dr. Richardson's source, by contrast, was his own experience in treatment of patients. In court, this one man's opinion should not overcome the giant mass of studies on this issue, but his charisma and impressive resume often caused judges to come down on his side. I was not about to go blow for blow with this doctor at trial without doing every ounce of research on him. A Google search of Dr. Richardson revealed many of his published papers, but none bearing on the subject we would be litigating at trial, whether Paris leg and rib fractures were indicative of child abuse. I also read transcripts of his battles with prosecutors in other trials. There was never any discussion of what his own prior research and published articles had to say about the matter. The doctor mostly cited his own day practice and knowledge as a means of proving that bucket handle fractures can happen by total accident. Then I had an idea. I remembered that in my orientation for the state's attorney's office, they told us that the office paid for various services that were available upon request, including access to a library of expert research that was not publicly available. I requested access to this database, and on searching, I found a batch of articles written by Dr. Richardson that I had not found on Google. I combed through them until I found one, a paper he co-authored 20 years prior, that specifically addressed bucket handle fractures in the legs of children. I laughed when I found the following sentence: "Many studies performed across the years have identified bone fracture types that are highly suspicious for and strongly indicative of child abuse. Such fractures include bucket, handle fractures, bilateral fractures, and posterior rib fractures. Baby Paris had bucket, handle fractures, bilateral fractures, and posterior rib fractures." Contrary to this paper he authored, Dr. Richardson's expert report in Paris case indicated that those types of fractures were not highly suspicious for child abuse. After all, he said, they were just as easily explained by the father accidentally lying down on the child, which the father did not even claim that he did. I wanted to nail him down to a more precise opinion before trial. So, I decided to go the extra Mile and have a deposition of Dr. Richardson. A deposition is an out-of-court session where one attorney grills the other attorney's witness with the attorney present, and a court reporter takes everything down. This is where you nail a witness down to what exactly they believe to be the truth. If they try to play games at trial, you can slap them with their deposition testimony, showing them to be inconsistent. This is called impeachment. Taking a deposition was a rare move in the Child Protection Division, where low funding and lack of time often prohibited the taking of depositions. Everyone in the division I spoke to suggested I do the same thing. They advised that in the deposition, I whip out the doctor's prior article about bucket, handle fractures being inherently suspicious, and get him to squirm and make statements admitting defeat, which I could then use against him at trial. I never automatically go with the grain, so I considered this technique with skepticism. Having read transcripts of his battles with prosecutors in depositions and at trial, I saw how clever he was, and I don't give such compliments easily, in wiggling out of weaknesses in his opinions. At deposition, where we have all the time in the world, he could ask for a moment to read through the article and concoct an elaborate excuse to explain everything away. In that case, I wouldn't have anything to use against him. So, I weaved a different web. I would not confront him in the deposition with his old article that contradicted his expert report. I would save that surprise for trial. I would instead, in the deposition, push him into the most radical version of his current opinion. I would get him riled up and push him into saying what his report implied, that against the weight of the scientific literature, bucket handle fractures were not at all, ever, indicative of child abuse. Then at trial, I would confront him with his article, revealing that he authored a paper supporting Paris, Treating Doctors, Conclusion of Abuse. On the hot seat at trial, he would not have the benefit of evading what he wrote in his own published article, because witnesses are not permitted to filibuster at trial as they might do in a deposition. I started out in the deposition with background questions, which are typical. I asked about his education, his board certifications, and his day-to-day treating of patients. Right out of the gate, he seemed perturbed by my questions. He had sat for depositions before, so he knew such questions were customary. But he simply could not help himself, speaking in an aggravated tone during the most perfunctory part of the deposition. I knew we were heading in the right direction. I moved on and asked him, one by one, to identify in the X-rays each of the fractures the pediatric treating physicians found. Upon examining the X-rays, he agreed that there were, indeed, fractures to the left and right tibiae and femurs, and to the posterior ribs. But the agreement ended there. He began offering his conclusions. He stated that bilateral rib fractures on both the left and the right side of the body, did not raise a suspicion of child abuse. He said that the ribs are like a hula hoop, encircling the body. If Paris' father truly did roll on top of her, the pressure on her ribs could have caused the ribs stress similar to if you squeeze a hula hoop, with breaks occurring in multiple places. Recall that Paris' father did not claim to have rolled on top of her. It was not necessarily the case, he said, that someone's hand squeezing the baby caused such fractures. The story he swapped in for the dad's actual story would almost make sense, but the doctor did not explain how lying down on the baby would have also caused multiple leg fractures. He just offered something like, "Yeah, those would break too." At this point, the doctor's arrogance began to show, and he said things like, "I don't know what these child abuse doctors have told you, but that's simply incorrect. There is nothing special about bucket handle fractures. Nothing at all. Let me enlighten you." He truly thought he could talk me out of believing what the treating physicians and the weight of the literature said, and in such a condescending manner. I challenged him in order to fan the flames of his perturbation, but I feigned confusion at what he was saying to fool him into thinking he could convince me that he was right. As he became more heated, he took more and more radical positions. He moved from the position that child abuse possibly caused Paris injuries to the position that child abuse definitely did not cause these injuries. And the cornerstone of his opinion was that nothing is inherently suspicious about bucket handle fractures. They are not a sign of anything. Then I casually moved on to my pied de resistance. I said, "Doctor, let me state some propositions, and tell me if you agree or disagree." I went sentence by sentence, reading direct quotes from his published article deeming these fractures as inherently suspicious for child abuse. But I did not tell him I was reading quotes from his article. I was walking him into a trap. Doctor, agree or disagree? Many studies performed across the years have identified bone fracture types that are highly suspicious for and indicative of child abuse. Such fractures include bucket handle fractures. Disagree. Bilateral fractures? Disagree. How about posterior rib fractures? Disagree. I proceeded in this manner for several propositions from his article. Now that he had entrenched himself in such a far-out position, he had to stick with it for trial, where I would surprise him with his own words. The day for trial arrived. The formal charge in this case was physical abuse. We had to prove that the parents inflicted physical injury on Paris, other than by accidental means. Therefore, the judge had to believe the child abuse doctors that the injuries in this case were explained by physical abuse and not by the baby being accidentally squeezed against the wall by the father or rolled on. I called my witnesses one by one. The DCFS investigator testified to what each parent said in the interviews and to the father's nervous, evasive demeanor, his ever-changing story, and the explanation he gave as an afterthought that he woke up to the baby between his arm and the wall. I also put on evidence to show that at all relevant times the baby was under the care of the parents to rule out that someone else caused the injury while their backs were turned. I also called as witnesses the physicians who examined and treated the baby, including the child abuse pediatric specialist, who concluded that Paris was abused based on the bucket. Handle fractures indication of abuse and the lack of any explanation by the parents. I rested my case. The defense then called its sole witness, Dr. Richardson. He put on a persuasive display for the judge deciding the case. He offered that, in his opinion, bucket handle fractures can be caused by ordinary accidental forces, like a father rolling over on top of a baby in his sleep. I made clear in my direct examination of the DCFS investigator that the father never claimed to have rolled on top of the baby, only saying the baby was between his arm and the wall by the bed. But everyone in the room began to just accept dad rolling over on baby as the alternative to parents abusing the baby, as though it were ever the only explanation offered. I then questioned Dr. Richardson as I had in the deposition, getting him to admit that yes, there were bucket handle fractures in the left and right tibiae and femurs, and yes, there were also fractures in the posterior ribs on both sides. He said he believed that the father's explanation fit the bill because rolling over on the baby could just as well have caused these injuries. Okay, I said, reading from his article as I had done in the deposition. Let me know if you agree with the following propositions. Many studies performed across the years have identified bone fracture types that are highly suspicious for and indicative of child abuse. Such fractures include bucket handle fractures. Recalling his deposition answers to the same questions, he indicated that he totally disagreed with these conclusions, stating that they had no basis in sound medicine. I then finished the quote, and he denied that posterior rib fractures and bilateral fractures were indicative of child abuse, as he had also done before. Doctor, I continued, did you author an article called Patterns of Leg Fractures in Children in 2002? His eyes became wide. Yes. What? I don't know what you're getting at. What does that have to do with any of this? I'm going to present you with the article. Flip to page 37. That's your signature on the final page, right? Yes. You authored this article? It was a long time ago, but, yes, I did, he said. Now, please turn to page 20. I then read the quote verbatim, whose conclusions he had just angrily denied in open court. I asked the narrow question, those were the words in this article, authored by you, correct? He demurred, yes, but, well, you don't understand. Doctor, it's a simple question. Were those your words or not? He was shaken by this attack, and he had trouble answering my simple question, though he did try. Mr. Moyer, as you can see, there are a few people I co-authored that article with, and I think they wanted to put that in there. Or, wait, I think that the editors actually made us put that in. Doctor, I said, You signed your name at the end of this article, right? Just like you signed your name on the expert report in this case? Yes, he said. Was your article about bucket handle fractures the only time you signed off on something you didn't really believe in? Or did you do that in this case too? I had made my point. Ultimately, the judge in this case, a wise man seasoned in the area of child abuse, made his ruling. He decided that he could not ultimately rule that the child had been abused, other than by accidental means, because we simply cannot know what happened behind closed doors, and injuries cannot themselves tell the story. This was a common practice for this judge. Unless a credible witness saw the abuse herself, or the child was old enough to describe the abuse, he would rarely find that physical abuse occurred. However, he found that the child was in fact abused by being exposed to a substantial risk of injury. He held that given all of the leg and rib fractures, clearly Paris was exposed to a high risk of injury somehow. It was basically a lesser included offense. This was his way of nodding to us that he knew the kid was abused, but without making so harsh of a ruling against the parents. This judge believed that by avoiding the finding of intentional abuse, he was showing the parents that he was in their corner and encouraging them to improve themselves. In this case, the parents had dutifully attended all therapy and parenting classes required. The judge was hoping to keep them encouraged and on course. In the child protection system, if the judge finds there was any type of abuse or neglect, even through mere risk of injury, then the case presses on, and the parents must continue taking parenting classes and fulfilling other requirements before getting their child back. So I was not peeved at the judge, who was a wisecracking, lifelong public servant that knew what he was doing. But I remained skeptical of the parents, one of whom had likely been in a fit of rage or under the influence of substances and badly abused the poor baby. I had a feeling the judge would rule this way, as I had seen him do so on other occasions. I was nonetheless proud that I deftly plotted and executed a trap for a feared expert witness and poked holes in his spurious pontification. His frustration, plus the look of amusement on the faces of the people in the courtroom, showed me that I had won the battle, if not the war. My public defender friend, who represented the parents, had a laugh with me about it after court. At this point, I was only a few years into the practice of law, and I was excited by this opportunity to go to battle with someone so practiced at outfoxing attorneys. I was stoked to come out on top. This episode may not seem as wild and crazy as courtroom battles on TV, but in the world of prosecution, many go along to get along, and do not walk into such confrontations to further their cases. I believe that great dramatic moments inspire and move an audience, so I do not shy away from them when the moment calls. This incident also persuaded me to make good and frequent use of surprise attacks, which often throw the opponent into disarray and tilt the scales in one's favor. Child support enforcement. In addition to juvenile crimes and child protection, I also did a stint in the Child Support Enforcement Division, chasing down men who failed to pay court, ordered child support to the primary caretaker of their kids. In Cook County, Illinois, where Chicago is located, there are thousands of active child support enforcement cases per year brought by the state attorney's office. This was a unique assignment because child support is litigated in family law courtrooms where divorces and custody battles occur. This is not often the battleground of criminal prosecutors, but through Illinois law, prosecutors are assigned to enter the courtroom and intervene in certain child support cases for the benefit of the child. We were not appointed as the mother's or father's attorney, but rather a neutral third party whose job was to ensure that a fair child support amount is set, and that the dad is paying his child support in full and on time. The Cook County State's Attorney's Office has a special branch just for this purpose, the Child Support Enforcement Division. Dealing with a high volume of cases as a child support prosecutor felt like an assembly line some days. I preferred the drama and action of daily court to the office, bound paper pushing of a corporate law firm, but with many cases I sometimes felt like any attorney, even the most lazy and unambitious, could get the same end result as I did. There are moments, however, where a prosecutor can be zealous and relentless, and because of that, get the right result by a narrow margin. That is the space I tried to live in as often as possible. I hoped that, by MUI efforts, I would be a net positive for the people of Chicago. What follows is, in my humble opinion, a case where my efforts paid dividends. The judges in the child support court had adopted a reading of one law that enabled the most egregious child support debtors to forever avoid paying child support to the mothers of their children. I was ultimately successful in my fight to bring sanity back to the law and stop this practice. This is a case that radicalized me, early in my career, into thinking that fighting hard can lead to great change. A big splash in a small pond. Daniel Johnson was not the average child support delinquent. He owed over $100,000 to the mother of his child and had not voluntarily paid her a dime in 16 years. Child support in Illinois is established through a formula that involves calculating the mother's income, the father's income, and identifying who is the primary caretaker. Johnson's child support obligation was established through a case brought by the Cook County Child Support Enforcement Division in 2003, around when his son was born. He was ordered to pay $300 per month for his infant child, $3,600 per year, so that the child's single mother could have financial assistance in raising the kid. But Johnson was not involved in this child's life in any way. Johnson did not even show up to court to acknowledge the mother or the child, or to contest how much child support he would be ordered to pay. Johnson proceeded to ignore his child support order, which is sadly very common in these cases. The only payments made to the mother were involuntary wage garnishments starting in 2008 and ending in 2009. The state of Illinois is notified if a child support debtor obtains legitimate W-2 employment and can order that the employer withhold the person's wages and send them to the government for the government to hand over to the mother. This is an administrative remedy used by the state to ding child support debtors who will not voluntarily pay the moms. It is administrative, in that there is no court process and no judge required to order the wages withheld and sent to the government. It is done purely through the state child support agency's own lawful power. It seemed that the brief period of wage garnishment was the only time Johnson had a real job. He also had several thousand garnished from his tax return from that period to pay toward the mounting debt. Outside of these limited involuntary repayments, Johnson paid nothing to the woman raising his child and had no part in the child's upbringing. While in prison in 2012, Johnson got the bright idea to sign a transmittal to the state of Illinois requesting that his monthly child support obligation be lessened on account of him being locked up and unable to make money. The government requested further paperwork from Johnson, but he blew it off. A father cannot make money while in a prison cell, so there is no legal basis for charging the father hundreds per month while he is totally incapable of paying it. If Johnson had simply filled out the requested forms, as required, his child support would likely have been paused. But alas, the extra paperwork was too much effort for him, so he did not complete the process. That brings me to 2019, when I became involved. Johnson retained the talents of one of the world's most hard-hitting, high-powered law firms to take care of his now over $100,000 in child support debt. Most mothers and fathers came into this process without attorneys at all, let alone attorneys that charge hundreds of dollars per hour per attorney. These big law attorneys had represented Johnson pro bono for free on a separate case and had extended their free representation to assist him with his child support issue. The first time I saw them, they appeared out of place in the down and dirty bustle of the county courtroom. Two of the attorneys were significantly taller and better dressed than everyone waiting around in court for the cattle call of family law cases to begin. One family law attorney in the room, whom I knew from her work on some of my cases, turned to me and said, "Who the hell do you think they are?" The law firm had a sweeping claim that would fully resolve Johnson's child support problem, if accepted by the judge. Their claim was that Johnson was not lawfully served with the paperwork at the inception of the case, and therefore had no knowledge of the case. If he wasn't properly served with court paperwork, the court had no power or personal jurisdiction over him in the case, so anything he was ordered to do, like pay child support, would be null and void. The entire $100,000 debt Johnson owed his kid's mom would be wiped out. Proving improper service of process, and therefore lack of court jurisdiction, was virtually the only way to wipe out massive child support debt. Judges in Illinois have no other legal authority to wipe a defendant's slate clean once they fall behind on child support. The debt becomes a judgment that is due and owing to the mother and cannot be vacated or voided by the judge. The law firm attorneys were cunning and skilled, but they did not pioneer the strategy of challenging service of process to get thousands in child support debt wiped clean. Legal aid attorneys had been doing this for a few years in the courthouse. Judges indulged this practice, as they often assigned the minimum monthly payment of $40 per month to fathers in the first place. On the back end, after the dad paid nothing, they would wipe out what the father owed by ruling, "I find that he was not properly served with the papers at the onset of the case." Most commonly, the dads were served with legal process, which usually just involves a sheriff deputy handing them court papers in a clearly sufficient manner that was well documented. So this courtroom practice frustrated me, and I knew something needed to be done about it. The most straightforward way a person can be served with legal papers is by personal service. You've likely seen movies where someone is served with lawsuit paperwork and a process server shoves the court papers at them and says, "You've been served." There's another way where the person serving the papers, most often a sheriff deputy, goes to the person's house and tries to serve them the papers. If the person isn't home, the papers can be left at the defendant's usual place of abode, their residence, with someone else who lives there, as long as the person is older than 13. The sheriff deputy serving the papers would confirm with whomever they hand the papers to that the father did, in fact, live there, and that they would pass the papers to the father. Court proceedings could not have proceeded against Johnson until his address was discovered, and where he or someone over 13 could be personally handed before substitute service at this address for a domestic incident, the court papers. In April of 2003, a sheriff deputy went to the home address associated with the defendant through a number of sources. He had in hand the summons directing Johnson to attend his first court date, and the petition filed by the government seeking to make him pay child support to his child's mother. According to the record kept by the deputy encountered someone named Ramirez at the home and marked that she was an African-American woman in her 40s. Johnson, mother's last name was Ramirez, and she was around the age noted by the sheriff deputy at the time. The sheriff would almost certainly have asked if Johnson lived there and confirmed that mom would give him the papers. Per the records, the mom did take the paperwork, and substitute service of process on another member of the house was complete. This means that Johnson was expected to show up to court, and the court then had power to order him to pay child support. The government knew Johnson lived at this address with his mom, and therefore that he should be served with the papers there, for several reasons. First, the government had his employment records from December of 2002, just 4 months prior to service, where Johnson had identified his mom's address as his home address to his employer. Next, Johnson was arrested less than a month, and he provided his home address to police as this address. Clearly, this was his place of abode, and another resident of the abode, his mother, accepted the papers. This was not a close case. In all likelihood, Johnson's mother informed him of the child support case, and Johnson totally ignored it. He certainly knew about it in 2008 and 2009 when his wage and income tax return were garnished to pay child support, and he certainly knew about it when he made a half-hearted effort to have his child support reduced while he was in prison. Nevertheless, he came forward in 2019, over 16 years after the case began, claiming service of process in 2003 was unlawful. He also claimed that he knew nothing of this child support order until 2019, which was ridiculous, given the wage and tax return garnishment and his attempt to halt the child support from prison. In support of his motion to quash service and void the child support order, Johnson claimed that he never lived at his mom's address. He also included sworn statements from his mother, who claimed she had no idea of her son's whereabouts during that time, and from his then-girlfriend and now wife, who stated that Johnson never lived at that address to her knowledge. If the address was not his usual place of abode, then the deputy's attempted service of the papers on the mom living there was improper, the court's power to charge him. Child support was null and void, and the $100,000 debt he owed to the mother would disappear. Rather than make a decision based on Johnson's filing and our written response detailing our arguments, the judge ordered that we hold an evidentiary hearing. This meant that Johnson and the people who had filed sworn statements for him would give testimony under oath before the judge and be questioned by his attorneys and cross-examined by me. The day of the hearing arrived, and I came with a binder of the evidence and an outline of the questions I intended to ask the defendant and his witnesses. The law firm on the other side hat. 3 attorneys and several staff members, shuffling papers around, busying themselves in a manner. The hearing involved our presentation of the evidence discussed above connecting Johnson to the address of service. We presented to the judge Johnson's employment records and other records where a defendant listed to employers, the government, and others that the address in question was his home address around the time he was served with the child support papers. After that, the hearing included the defendant's testimony. Unsurprisingly, he claimed that he never lived at that house. He said he was transient in 2003, living an up-to-no-good lifestyle where he was couch to couch, staying with friends in Chicago. When pressed about why he informed his employer and police that his mom's address was his home address, he stated that he just received some of his mail there since he was such a vagabond and had nowhere else to receive it. His argument was essentially that he had no abode to be lawfully served at, which is quite self-serving because it would mean that substitute service papers handed to someone in his abode could never be made on him. So no court could obtain power over him in this way. How convenient. I had a massive gotcha moment during his testimony that, in a different jurisdiction, may have ended the case then and there. The case law, binding appeals court rulings, gave us a helpful principle. While haggling over whether a place is a person's abode for service purposes, judges cannot forget to ask the basic question: what was the most reasonable place for a defendant to receive notice of the court case pending against him? We could bicker about whether Johnson holding himself out as living with his mom to his job and to the police really meant he lived there. It did. But if he's telling everyone he lives there, he gets mail there, and his mom lives there, then it's the best and maybe only place for him to be notified of his court cases. I got the bold idea of having Johnson tell me himself that this was the case. Johnson gave me an opening. In questioning by his lawyers, he was quick to defend his mother, who had filed a sworn statement saying Johnson did not live with her when the papers were served, but had failed to show up for the hearing to back up her statement and submit to my questioning. Overcompensating for her absence, he said things like, "Her memory is really good, and she is very honest and reliable." I knew I could bait him into something. My plan was to get him to admit that his Moni was so damn reliable that the court papers were better off having been handed to her than even to him back in 2003. This would answer the bottom line, overarching question of where was the best place for Johnson to be notified of a court case. My cross-examination of him went something like this. Q. Let's talk about your mother. You say she's reliable, right? A. Yep. She's the most reliable person I know. Q. You say she has a good memory? A. The best. Better than mine. Q. That is true today, right? A. Yep. Q. And it was also true in 2-03, wasn't it? A. Yes. Absolutely. Q. In 2003, your mother's memory was even better than your own. Yes. Q. And she was more reliable than you were then? A. Yes. Q. You were living all over the place, you say? A. I was. Q. In 2003, if any important mail came in for you, she would have been reliable enough to pass it along to you, wouldn't she? A. Definitely. Q. In fact, if court documents were sent to you, it was better for you if your mom received them than if you received them. A. Yes. Q. Because she would be better than you at remembering whether you had any court dates upcoming, right? A. Yep. She was the best with that. Johnson's attorneys put their heads in their hands. Johnson thought he had to defend his mother by saying as many good things about her as possible to make up for her failure to appear in court. I knew this and fooled him into saying that his mom's address was the best possible place for him to receive notice, which under the case law was the key question for determining where someone's abode was for service of process. The judge, who is mostly a fair and reasonable guy, went on to rule against us. He invoked the typical misreading of the law to make this happen, as all the judges were doing at this time. The judge cited the case of Stern v. Forrest for one line in the case, which made it nearly impossible for us to win. Where service of process is challenged by affidavit and there are no counter affidavits, the sheriff's documenting of service itself is not even evidence, and, absent testimony by the deputy, the defendant's affidavits must be taken as true, and the purported service of summons quashed. In short, if the prosecutor cannot find the sheriff deputy who served the papers umpteen years ago and has no direct witness to file an affidavit to counter the defense, then all statements made by the defense witnesses in their affidavits must be accepted as true. On its face, this would be a ridiculous rule, but it wasn't the rule. What this judge and all of the others failed to discuss was that the Stern case, after stating the above, concluded that the rule was outdated, a relic of another time, and the party defending a motion like ours could attack it exactly as we did, with documentary evidence or whatever else may create doubt as to the defendant's claims that he did not live where he was served papers. The party who had served the papers in Stern proved their case just like we did, and they won. Yet the judges treated Stern like its reasoning was a cudgel against us, simply by misusing one line in the case citing the old rule. We had no counter affidavits to file, as there was no witness we could find that could tell us definitively that in April of 2003, Johnson did or did not have his mom's address as his abode. We also could not locate the sheriff's deputy who did the service, as his name was illegible on the forms, and even if we did locate him, he would not have a memory of handing someone papers 16 years prior. So we had no counter affidavits to file. Instead, we relied on our hard proof the defendant's own actions, holding himself out as living at that address to police and to his employer. In the Stern case, the litigant in our shoes used the same kind of proof and ultimately prevailed, so the case cut in our favor. Yet the judge used the same upside down reading of the case to say, "You don't have the sheriff deputy or counter affidavits, so you lose," and ruled for Johnson. The $100,000 he owed vanished from the books. I spent the next few weeks doing what I could to get this decision overturned. I filed a lengthy motion asking the judge to reconsider his decision. I highlighted how Stern does not actually require us to present the sheriff deputy or counter affidavits, and I cited cases coming after Stern that followed the same path. The judge remarked that he read any motion and drafted a lengthy opinion overturning himself and reinstating the over $100,000 owed by Johnson. But ultimately, he said, he changed his mind and thought it better to deny my motion and let us hash it out on appeal. This was a tacit admission that I was right, but a confession that he preferred to maintain his stance, holding the line with the other judges in the building. I made phone call after phone call and held meeting after meeting to convince the necessary parties to appeal this matter. You'd think it'd be automatic for prosecutors to appeal bad decisions in court cases, but there are so many decisions made against prosecutors that only in rare cases are bad decisions actually appealed. There just aren't enough resources to spend the time appealing every unfavorable outcome. For my case, it ultimately wouldn't be the Cook County State's Attorney's Office who would appeal, but the Illinois Office of the Attorney General. They were assigned to handle the rare child support appeal that merited the big wigs stepping in and righting the ship. I had meetings with them, pitching the importance of the appeal to a boss within the appeals unit of the Attorney General's office. That high-ranking attorney and her staff agreed that the judge misinterpreting Stern needed to be set straight and cut it out with letting people get out of paying for their children through a strained reading of the law. My supervisor could not remember the last time they agreed to handle an appeal coming from our division. It was not common. But they took the big wig law firm to the appellate court, doubling down on the arguments I had made in the lower court, and the good guys won. The appeals court agreed with us that Stern did not require the serving party to call the sheriff deputy or present counter, affidavits, arbitrary requirements that had no basis in the law. The court agreed that we successfully rebutted the defendant's claim that he did not reside at the place where the sheriff served the papers. Because it was an appeals court decision, the reasoning of this case became binding on the lower courts, the ones where the decisions on child support are made. Chicago judges, as of the writing of this book, are no longer free to let child support debtors off the hook. Prosecutors confronting similar claims made by the delinquent dads do not have the ludicrous task of finding the sheriff deputy in charge of serving papers in decades-old cases. Instead, they can prove that the defendant lived exactly where the proof shows he lived. This case made it much more difficult for child support delinquents to get off scot-free. The sweetest part for me was that Johnson once more owed over $100,000 to the woman who raised his child with no help. I share this story because, while it was in no way a high-profile case, it exemplifies challenges young litigators face in public interest work, moving law in the direction of justice, holding accountable those who refuse to follow the law, and the difficulty of cutting through red tape behind the scenes to get things done. Seeing my efforts lead to great change as a young attorney, I realized that clever tactics and bold efforts can net sizable change, even in a system hell-bent on making things difficult and unpredictable. Little did I know, big things were just around the bend. Federal criminal prosecution. I cherished my time as a prosecutor in the Cook County State's Attorney's Office. But I had been dreaming of catching bigger fish, of fighting high-profile battles in federal court. I became a federal prosecutor after sending in a long-shot application. Just prior to starting the job, I got married, moved out to the suburbs with my wife, and got our golden retriever. This next chapter in my life brought significant cases with their own challenges. Taking on criminals who commit complex, carefully concealed crimes required me to become an investigative prosecutor. I worked with federal agents from the outset to develop evidence that would form the basis of unbeatable federal charges. I knew this job would be intense from my first day. I sat in the waiting room of the office with my head on a swivel, wondering if the others in the room were starting the job with me. 3 other guys sat across from me, wearing suits, looking like it was also their first days. We got to talking, and I found that these guys were the real deal. The youngest of them was a few years older than me, and a Navy JAG lawyer, which was the role held by Tom Cruise and a few good men. Another of the guys had practiced in one of the world's top law firms and seemed to know everybody in the legal community in Chicago. The third guy was also at another one of the world's best law firms, and he had served our nation in a combat role as a Navy SEAL in the Middle East. Confident though I may be, I wondered if I was out of my league. These guys I started with were exceptional. But as it turns out, many people I would go on to meet at the office were just as impressive as these guys. The U.S. Attorney's Office in Chicago has earned its reputation by hiring top talent and by slaying giants in court, from corrupt politicians to gang leaders to terrorists. Due to the sensitive nature of federal cases, below I have included fictionalized stories that are merely inspired by a large combination of the cases I handled. I have contrived names, dates, locations, and entire characters to prevent any association with real defendants. My intent is to convey how federal cases are investigated, charged, and litigated without speaking of any actual cases. Lights, camera, fraud. After 2 months on the job, I was assigned to investigate a robbery crew. In Chicago around this time, the city was plagued by crews of armed robbers cornering people on public streets. They would beat helpless people who had no ability to fight back, sometimes shooting them, always taking their belongings. Many robbery crews would also have the victims unlock their phones so that the robbers could take the phones home and wire themselves as much money as the bank accounts would allow. Indeed, robbers have evolved, knowing that people do not carry much cash anymore. I have seen cases where robbers would use every payment app on the victim's phone, PayPal, Venmo, Zelle, and send themselves or a burner account thousands of dollars. These robbery crews were and are the scourge of the people of the Windy City. The stick-up crew I investigated was nothing like that. From the start, little made sense about their actions. They were unique in that they were almost exclusively attacking people in Mexican grocery stores, bodegas, and cantinas, always between the hours of 6 p.m. and 8 p.m. The crew would often rough up the victims, striking and kicking them on the ground. They took possessions from the victims, but made a big production out of the stick-up itself. They would point, laugh, flash gang signs, and wave Mexican flags as they robbed people. Taking their possessions almost seemed like an afterthought to the beat down. We figured it was a robbery crew with a unique brand of sadism that involved taunting their victims for a thrill. The crew included a driver, who would remain in the getaway car, and 2 to 4 others who would enter the establishments, rob the registers and everyone inside, and strike the victims on the ground, taunting them. Oddly, the take from the victims and the cash register was usually no more than $100. Split multiple ways, it was hardly enough money to justify committing a felony that could land a guy in prison. Noting the oddness of it all, we pressed forth with our investigation, assuming that these robbers, like many others, may be doing this more for sport than for money. As you will see, this case was ultimately about neither sport nor money, but something far more peculiar. This investigation was my first experience with how skilled FBI agents can be at tracking down perpetrators of crimes. At the outset, finding the culprits seemed nearly impossible to me. The robbers all wore matching dark clothing, including dark face coverings during the beatings. Further, while they used the same gray sedan as the getaway vehicle most times, the car seemed untraceable to me. The criminals would attach stolen license plates to the gray sedan right before approaching the robbery location. Surveillance footage from the outside of the stores would show the car with a different license plate each time. Without being able to trace the car to its real owner, I thought it would be rather difficult to find the culprits. But the FBI had their ways. Agents obtained police observation device, POD, footage from intersections near the robberies from Chicago police. A team of agents combed through all the POD footage for many of the stick, up yes. If for a given case, the robbers' car sped away from the location in a southern direction, the agents would look at all available footage of traffic within several miles to the south of the location. This required long hours of combing through footage, and it required extreme focus, as the agents had to pinpoint one vehicle among many in blurry footage. The theory was that, at some point in the getaway, the robbers would switch the license plate from the stolen plate back to its real plate. They would need to. Otherwise, automated license plate readers would detect the stolen plates. License plate readers are devices positioned at intersections and on roadsides throughout the city. They detect every license plate that passes by them and logs the plate number in a database. Law enforcement can enter a number of a stolen license plate in the system and receive an alert when it passes by a plate reader. Criminals know this. If our culprits were smart enough to attach stolen plates to their car close to the robbery scene, they would be smart enough to remove them fairly quickly, to avoid triggering these automated license plate readers. If we could capture the car driving with its real plates, we could run the plates in the system and see who owned the car. This person could lead us to the robbers. Sure enough, officers reviewing POD footage saw the gray sedan riding with its real plates through an intersection miles from the robbery location. I cannot imagine how many hours of footage they trudged through to discover this. The officers knew it was the same gray sedan, despite the changed-out license plate, because of distinct damage to the paneling of the car and a unique sticker on one of the passenger windows. Officers ran the true license plate in their system and found that it belonged to Kelvin Fernandez. This is hardly a real lead, as it's common in the criminal underworld of Chicago for people to borrow another's car to commit a crime. Officers attempting to interview the guy could expect that he'd slam the door in their face and refuse to talk. But they took note of his name, searched up where he lived, and checked POD footage from near his house. Officers saw the gray sedan parked on the street in front of his house nightly on the footage. The first major break in the case came when a keen police officer, working with the FBI, noticed something from the footage of the gray sedan in traffic. Traveling with the Kelvin Fernandez's gray sedan was a second car, following a few cars behind. In all of the POD footage where the gray sedan appeared, so did the other sedan, albeit following at a distance. This occurred on the same cold January night that a Mexican bodega was robbed. What are the odds that the two cars would travel the same routes together, unconnected? Officers ran the plates of the second car and discovered that it belonged to Drive Now, a rental car company located on the west side of Chicago. Officers reached out to Drive Now's management, who were happy to help identify the driver of that vehicle. Drive Now searched its records and reported that the car did belong to them, but was not rented out on the date in question. However, the manager said he had allowed one of his employees to borrow that car occasionally because he did not have a way to get to and from work. His name was Diego Wilfredo. The manager added that Diego Wilfredo was best friends with another Drive Now employee, Kelvin Fernandez, the owner of the gray sedan. FBI then checked Drive Now's surveillance footage from the day in January when the gray sedan and the Drive Now sedan were in traffic together after the bodega robbery. Kelvin Fernandez had come to work in his gray sedan. Around 5 p.m., Fernandez and Wilfredo were hanging out together near the lobby of the building. The footage showed them shooting the breeze, laughing, shadowboxing in each other's direction, and so forth. After a while, Fernandez left work in his gray sedan, and Wilfredo followed right behind in the Drive Now sedan. A few hours later, the bodega was robbed, with Fernandez's gray sedan transporting the robbers, and Wilfredo's Drive Now car following behind. We now had two prime suspects. The crew struck every few nights, but it was about 1 month later that they slipped up. Both Fernandez and Wilfredo had bought new cars by this point. The FBI knew this because they continued to watch the pod camera located near Fernandez's house and saw him and Wilfredo driving and parking new cars. On one freezing February night, they observed Fernandez in his new car and saw him meeting with Wilfredo in his new car at a Mexican grocery store, having followed them on the cameras. A third guy came to the Mexican grocery store and hung out with Fernandez and Wilfredo. Officers identified him as Raul Tomas. Raul Tomas was heavier than the other two, who were of slim build. Tomas drove a sedan with a broken headlight. Gas station footage showed the three talking outside of one of the cars at a gas pump. Then Tomas, the third guy, walked into the Mexican grocery store with his pants sagging down. Gas station footage showed the greater part of his underwear, which was SpongeBob themed. Specifically, the design was a mural of the Krusty Krab, stitched in bright colors. Tomas' underwear would prove to be the crew's ultimate downfall. About an hour and a half after the Mexican grocery store meet-up, a Mexican bakery was robbed. Tomas' sedan, with the unmistakable broken headlight, pulled up to the place. The car idled for a few minutes. Then, three men, wearing black clothing and face coverings, jumped out of the car and ran inside. Within the bakery, a few employees were toiling away, shuffling things around and cleaning. Later, looking at the surveillance footage, I thought they were trying to look busy. Something seemed unnatural and forced about their movements and actions. All were of Mexican descent. There were also 3 customers inside. One was a Mexican man, seated at a table, both hands clasping a full cup of black coffee, which he was not drinking. He repeatedly looked at the entrance. The other customers were 2 older Mexican women who stood at the counter, speaking to the cashier. This bakery was a weird place to hang out at 7 p.m. But stranger things have happened, I thought. The 3 robbers barged through the doors. 2 were of thin build. One was noticeably heavier. One of the skinny ones pointed a gun at patrons and employees. The 3 shook down everyone inside the bakery, taking purses and wallets from the victims. The victims appeared scared, with visibly wide eyes, their hands flung up in the air. The bigger guy loafed back to the register and took some cash. As the crew exited, the big guy dropped money on the ground. He bent over, and voila! SpongeBob underwear, sticking out above his sagging waistband. You may have already figured out that the robbery was committed by Fernandez, Wilfredo, and Tomas, but we did not have enough evidence for a federal case until Tomas was outed by his unique underwear and the use of his identifiable car, with its broken taillight, as the getaway car. The crew did its usual routine, making sure to point at and taunt the victims, yelling things at them we could not quite make out, and flashing gang signs at them. We decided that we had enough to charge Raul Tomas with these robberies. His car, his underwear, his heavy, set build, and some unique shoes he wore in the Mexican grocery store first, and during the bakery robbery later, gave us enough. But we didn't have quite enough for a federal case against Fernandez and Wilfredo. Sure, Fernandez's gray sedan was seen at numerous robberies, and Wilfredo's car had moved in traffic with Fernandez's. And more, Fernandez and Wilfredo were hanging out with Tomas shortly before the bakery attack. But this didn't quite cut it to prove that they were our masked culprits, at least for now. So we drafted a criminal complaint, detailing the charge of robbery against Tomas, showing how we knew it was him. At the same time, we sought and received search warrants for Fernandez's cell phone and Wilfredo's cell phone. Cell phones are treasure troves of information. Criminals communicate by text message and on other apps, and are often too cocky to delete messages, not suspecting they'll ever be caught. We hope to recover enough from their phones to prove their involvement with the stick-ups. FBI agents, with the criminal complaint and warrant in hand, found Tomas at his home and placed him under arrest. They took him to FBI headquarters for questioning. Agents also went to Drive Now and found Fernandez and Wilfredo working. Fernandez was totally caught off guard. Agents restrained him and grabbed his cell phone. Wilfredo had seen the agents coming. By the time they confronted him, He had hidden his phone somewhere, and agents could not find it. But we knew we could get a search warrant for his iCloud account. iCloud takes the information on an iPhone, text messages, photos, call history, even location data, makes a copy of the information and places it in the cloud or remote servers run by Apple. At the time, iCloud did not automatically encrypt iCloud data, so we would be able to review the contents of his phone without ever finding the phone itself. As technology evolves, so do the tricks law enforcement can use to uncover evidence of crimes. Back at the FBI, Tomas was under the spotlight. He was vigorously questioned by two very skilled FBI agents. At first, he denied being involved with the robbery, but the agents confronted him with the evidence. What are the odds that it was someone else? Someone with the same build, wearing the same underwear and shoes, whose car also had a broken headlight. Tomas realized the jig was up, so he confessed. Yes, he said. He was the guy in the surveillance footage inside of the Mexican bakery taking money from the cash register. He also admitted that Fernandez and Wilfredo were involved. But, he said, the agents needed to know something. This wasn't a normal robbery. There was a man, El Jefe, whom he, Fernandez, and Wilfredo answered to. El Jefe spoke to them on speakerphone before the robberies and told them what to do. He was very specific. He would tell them how many people would be inside the location. He would explain how to shake them down. He would also tell them to use very specific gang signals, to taunt the victims, but to use different methods each time. He told them to always act like they were striking the victims on the ground, but to never actually hurt them. El Jefe was always nearby during the robberies, making sure things went smoothly, Tomas said. A few weeks later, agents had executed the search warrant on Fernandez's phone. They found conversations with Wilfredo, his drive now buddy, about meeting up to commit the jobs, or licks, as they called them. Fernandez's phone also contained conversations with Raul Tomas and several others, where they'd message each other addresses of places that would be robbed that day. Fernandez would also say things like, "Wear all black," and "Bring your strap gun." We had also received cell site information for Fernandez and Wilfredo to pinpoint their locations over the last few months. Cell site data tells you the location of every cell tower antenna that a phone connects to over a given time period. As a person moves throughout a city, their phone connects to the nearest cell tower antenna and will constantly connect to new cell towers as a person moves further from one and closer to another. In a densely populated city like Chicago, there are cell towers everywhere, thousands of them. So knowing what towers a phone is connecting to and where those towers are located provides great evidence of a person's location and route of travel. As it turns out, Wilfredo's phone had connected to cell towers located just a few hundred feet from multiple robbed locations. This included the bakery, where, after the robbery, Wilfredo's drive-now car followed Fernandez's gray sedan in traffic. Fernandez's cell site data showed him to be present at almost all of the robberies we had investigated, which was no surprise, since his old car, the gray sedan, had been the getaway car at almost all of the robbery attacks. This information gave us enough for criminal complaints against Fernandez and Wilfredo. Based on the evidence, the FBI arrested Wilfredo and Fernandez about a month after Tomas' arrest and confession. The FBI sat them down to be interviewed after their arrests. Fernandez, whom we could pin with more than 10 crimes, invoked his right to remain silent and refused to talk. Wilfredo, however, gave us some interesting information. Wilfredo made no mention of El Jefe. He seemed very defeated and did not say much, though he admitted to his own involvement in several robberies. Then, at the end of the interview, he looked up at agents and said, "You know the robberies are staged, right?" At first, the agents brushed this off as a poor excuse. What could you possibly mean by that? Wilfredo told them, "The robberies are staged. When we take purses and wallets, they are always totally empty." Shortly after giving this information, he invoked his right to remain silent and refused to talk further. Between Tomas' statement that El Jefe dictated every move of the robberies and Wilfredo's comments that the robberies were staged, I knew that there was much more to the story. The agents initially thought the crooks were just trying to wiggle out of trouble, but they agreed we should look further into the matter. So the FBI began gathering more information. I looked at the police reports and surveillance footage to see if I noticed anything off. I recalled the customer sitting down at the bakery with a full cup of coffee, not taking so much as a single sip, but staring at the door until he was robbed. I combed through videos of the robberies to look for other irregularities. I started with the February robbery, where Raul Tomas had exposed his drawers. I paused the frame as the robbers took the belongings of each of the victims and struck and taunted them. I zoomed in on these victinis, wondering if their faces would show signs that they knew this robbery was fake. Most looked pretty convincingly scared, but one young Mexican employee, positioned next to the cash register, raised his hands up in the air right as the robbers entered the building, not needing even a second to clock that a violent robbery was taking place. He kept his hands up in the air throughout the robbery and for a significant amount of time after the robbers left. At one point, hands still raised, he squatted down, right next to another male employee. He looked at the other employee. I zoomed in on his face. For the smallest moment, the victim bared a grin, a smirk even. It disappeared as quickly as it had come. This is the moment I knew it was all a ruse. I called out to my buddy, the prosecutor in the office neighboring mine, whom I had kept updated on the state of this weird case. Yo, come look at this guy's face. Does he look scared, or is he full of shit? My friend cackled and said, Dude, that guy is totally full of shit. What could be the purpose of staging robberies at a bakery or bodega? And why would anyone voluntarily get beaten and robbed at gunpoint? The FBI had been doing its homework, and we inched closer to figuring out why. In the over 10 robberies we were aware of, all of the victims at all of the robberies were Mexican, from one particular area of Mexico. We also found that the victims of each robbery were often family members, or close friends with each other. The FBI found some other oddities. 2 Mexican men owned one cantina that was attacked, and they also owned a Mexican grocery store 60 miles away that was attacked in the same manner by our same culprits. We also found that 3 different managers who showed up on scene to provide police with the surveillance footage had been present at approximately 9 incidents combined. Between the common nationality of the victims, the connections between the owners, managers, and victims, and the confessions of the culprits, we were certain that these crimes were fake. The why was provided when Chicago police reached out to the FBI with curious news. A gas station in Chicago had been victimized twice, 6 months apart, in the same exact manner. Both included employees having a large number of friends and family hanging out with them in the gas station inexplicably, when they were all suddenly beaten and robbed. In both cases, a few weeks after the robberies, the victims of the robberies all sent a Form I to 589% affidavit to the Chicago Police Department for signature. The Form 1-589 is the form used to obtain asylum in the United States. Asylum is a form of protection granted to immigrants who cannot return to their home country because they face violent persecution. Asylum seekers must prove they are in danger for reasons such as race, religion, nationality, political opinion, or membership in a particular social group from their home country. A person already inside the U.S. applies by filing a detailed application, the Form I-589, and supporting evidence with immigration authorities. If approved, asylum stops any deportation proceedings and grants the applicant the right to remain in the U.S., work legally, and eventually apply for a green card and citizenship. The supporting evidence submitted by the asylum seeker often includes affidavits, which are sworn statements by a witness. The people attacked in the gas station all claimed that the attackers had been following them before striking, and they claimed the attackers yelled out slogans from a Mexican political group that was persecuting people in the part of Mexico they came from. These victims claimed to be part of a minority political group that was under attack both in Mexico and America. We contacted the Chicago Police Department, since most of the robbery beatings had occurred in Chicago. We asked them to access their file of pending requests, and to inform us if the victims of our suspected fake robberies had sent then affidavits asking CPD to sign off on the story that these stick, UPS had happened. Across more than 10 cases, the victims had sent in affidavits in need of signature in almost all of them. We contacted the police departments of suburbs where suspected fake robberies had occurred as well and got the same answer. Victims had sent in asylum affidavits in almost all cases. This new information allowed us to form our theory. El Jefe was paying our robbers to rob people at specific places and times, making the robberies and subsequent beatings seem to be politically motivated. El Jefe instructed the robbers to taunt and beat the victims, to flash gang hand symbols, and to wave the Mexican flag at them. But the victims were in on it. In fact, this whole ruse was meant to help these fake victims become legal through asylum. The many fake victims paid El Jefe to stage these attacks so the victims could claim that they were being persecuted by other Mexican nationals who attacked them on orders from political groups, gangs, and cartels back home. This would enable the victims to claim that they were in danger and simply could not return to Mexico. I have to admit, it was pretty clever. To charge the wrongdoers with federal crimes, we needed to do a lot more legwork. We needed to discover the identity of El Jefe, whom we now assumed was of Mexican origin, given that most of his clientele was from Mexico. We also needed to find out when and how he communicated with the robbery crew to direct them. We further needed to uncover how El Jefe knew and communicated with the victims, and how they paid him to set up the fake attacks for them. As the investigation continued, the agents analyzed the phones belonging to Wilfredo, Fernandez, and Tomas, the phony robbers. Cellebrite is a company that provides a machine that extracts all recoverable data from a cell phone and organizes it into a readable format for law enforcement. In the Cellebrite data extractions, we found Wilfredo, Fernandez, and Tomas conversing amongst themselves about which locations they would be robbing. But we found a fourth person, Cristo Yaren, who seemed to be texting one or more of them addresses, which were later robbed, prior to the three conversing amongst themselves about the plan. Yaren seemed to be friends with these guys, but also the shot caller of the actor-assailants. We surmised he may be the point of contact between the robbers and El Jefe, especially since we found no evidence of contact between Fernandez, Wilfredo, or Tomas, and anyone who could be the mastermind of such a scheme. So we subpoenaed the call records, which we call tolls, for the robber, ringleader, Cristo Yaren. Yaren had loads of calls with the guys we knew to be robbers, right around the times of the robberies, which was unsurprising. This, plus the texts directing the robbers where to go and when, would be good evidence should we decide to charge Yaren. But we wanted to get to the bottom of things and find El Jefe himself, as he pulled the strings of everyone in the scheme ultimately. He directed Yaren, who directed the beatdown crew, which included Tomas, Wilfredo, and Fernandez. Agents, analyzing the tolls, found one number that Yaren had calls with before and after each robbery. We subpoenaed T-Mobile for that phone number's subscriber records and call history, and found that it belonged to a Pablo Noel. This had to be our man, El Jefe. Pablo Noel's tolls showed him to have contact with several people claiming to be victims. We knew the victim phone numbers because they provided their numbers to police for follow-up contact after reporting the robberies. After all, they had to be cooperative with police, as they would later ask the police to sign affidavits. Confirming the stick-ups were real. We made a spreadsheet of all victims, their names, dates of birth, whether they sent the Form 1589 affidavit for law enforcement certification that they were a victim, and we included their phone numbers on the spreadsheet too. We also marked down whether the victim had contact with Noel prior to or after the attacks. I knew we would need to lean on these would be victims to identify Noel directly and describe how he ran this scheme. We could not make the case solely on phone contact between the perpetrators. At this point, agents began building a profile on Noel so we could find avenues to proving he was the culprit. There are a few databases that law enforcement has access to that enable them to learn a boatload about someone. Is left. If you plug in someone's date of birth, name, social security number, and other details, the database will provide a whole profile on them. The database is fed by things like home buying records, utility bills, vehicle registration, birth certificates, and more. We found our Pablo Noel, who was a 27-year-old Mexican national. With Noel, we did not find any vehicles registered to him, but we found that Noel's home address was the same as his mother and father's. We looked into the mother and father to develop our understanding of who Noel was. His mother had a black Cadillac Escalade registered to her name per the database. We recalled that in an interview with Fernandez, the driver of the gray sedan. He told us that Yaren, the robber leader, once pointed to a black Cadillac Escalade, and said, "That's El Jefe. He's over there watching us. He's always watching us." Fernandez was positive it was a black Cadillac Escalade that Yaren had pointed out. So when we learned from Clear that Noel's mother owned an Escalade, we went to work. We pulled her license plate number from the Fly Secretary of State database that agents had access to. Once we had that, we identified license plate readers located nearby the scenes of the fake robberies to see if they clocked Noel's mom's license plates. Sure enough, this black Cadillac was picked up by the license plate readers near the crime scenes shortly before and after on many occasions. It became obvious that Noel was using his mother's car, thinking it would keep him better under wraps as he lurked nearby each crime scene. We also figured Noel must be getting paid by the fake victims. It's unlikely he'd be running an immigration fraud scheme for free, after all. So we went about finding out where he banked. We did our usual trick. We asked the credit reporting agencies for any and all lines of credit open for Pablo Noel, listing his date of birth, among other details we'd gathered. We found one account with Chase Bank. We subpoenaed Noel's banking records so we could look for suspicious transactions. To peek under the hood of people's phones and their social media accounts, or to enter their home, you need a full search warrant. In a search warrant application to a federal judge, you demonstrate by describing the crimes that evidence of the crime will be located in some private digital or physical location. A judge has to sign off on the warrant, finding probable cause to believe that a crime has been committed and the information you're seeking will be where you say that it will be. But for bank records, which include all customer information, account balances, and all transactions, deposits, and withdrawals, the government simply has to subpoena the information, and we could get it in a snap. Noel's banking records did not inspire confidence that he was a criminal genius. In the days leading up to a given staged robbery, he would have one giant deposit of tens of thousands of dollars of cash into his account. We knew it must mean that he was paid in cash by the beatdown victims, depositing it all into his account at once. This was excellent proof of Noel being the mastermind of this scheme and showed he was probably not so careful. I noticed that for staged robberies with a high number of fake victims, the deposits into his Chase account would be higher. Often the deposit would be done with a check written to him by a casino in Illinois. Criminals will take cash from fraud schemes or drug deals to a casino, play around a little without losing much, then have the casino cut them a check for the proceeds. They think this makes the money dumped into their bank accounts look like it's from a genuine source. Gambling winnings. It's not all that clever, as law enforcement has long been hip to this trick. We subpoenaed Noel's playing records from this casino and found out he was not even laundering the money there at all. The casino employee who provided me with the records walked me through them. The casino kept detailed customer records. The records revealed how much money customers put on their casino cards, or how many chips they bought, and for what value. Then, once at the table, the casino somehow kept track of how much the person made or lost at the table. The record keeper informed me that on more occasions than not, Noel would come to the table, bet thousands or tens of thousands, and lose it all. He was just a degenerate gambler, not a money launderer. This helped us build a better understanding of Noel. He was a prolific fraudster, but being in his mid-20s was not exactly a veteran criminal. We knew he had left behind more evidence for us to uncover. Our next task was locating fake robbers who had not been caught yet, and seeing if they would confess and identify Noel as the guy who hired them to have his friends rob people. Fernandez, Wilfredo, and Tomas had the incentive to help us, because convincing us that the robberies were fake would absolve them of their federal robbery charges. This was great, but having an ulterior motive made them less credible witnesses. We also did not want to approach the robber, leader Yaren, because he was a top target, and we did not want to give him a chance to be a cooperator for us, which would enable him to avoid more serious punishment. So we identified a fake robber we hadn't charged yet. I'll call him Jeremy. Using the Clear database, we found out where Jeremy lived. We sent him a target letter, where we basically said, "You are the target of a federal investigation. Contact us as soon as possible." The point of the target letter was to indicate to the guy we were interested in talking to him, which meant that we are also considering making him a cooperator and giving him a deal where his sentence would be less than if he refused to help us. Jeremy gave the FBI agents a call after receiving the letter. He agreed to meet with them and tell his story. Personally, I was more than willing to give Jeremy a sweet deal were he to thumb Noel and Yaren as the top dogs in the fraud scheme. Jeremy and the other robbers seemed to be living extremely humble lives, in contrast to Noel, who was gambling tens of thousands away and eating at high-end restaurants. We had already obtained a warrant for Jeremy's cell site information, which placed him at a few of the almost 20 staged robberies we were aware of. We told him this, and that we had cooperators who named Jeremy as being a member of the robber crew. He said he would come in and give up the plot. We interviewed Jeremy, who appeared nervous and cautious in our presence. Getting basic details from him was difficult at first. He went quiet for long periods, was shuffling in his chair and looking down at the table in front of him. He asked for multiple breaks in the interview so he could think about things. People in the criminal underworld have immense fears of being caught up in a federal case, so it can take time to break the ice. Eventually, we got somewhere with him. He told us how we came to know Pablo Noel, El Jefe, through Yarin. The robber ringleader Yarin had explained everything to him. Yarin said Jeremy and his friends could make some extra money working for Yarin and Noel. All they had to do was go to certain stores and restaurants, fake like they were beating people, flash certain hand symbols, take their stuff, and run away before the police could arrive on scene. Yarin explained to Jeremy that the purpose was for the victims, who were actually paying customers of Noel, to claim persecution by Mexican nationals and seek asylum in the United States. Jeremy had a higher level of knowledge than Fernandez, Wilfredo, and Tomas, who seemed in the dark about the full details of the fraud scheme, just happy to make their pittance with fake shake-downs. Pablo Noel explained to Yarin, who explained to Jeremy, that many of the people posing as victims for asylum would be coming in from out of state. Noel asked that Yarin hire friends like Jeremy to act as the robbers so that Noel and Yarin would have some separation from the scheme and manage it from afar. Noel arranged that he and Yarin would meet up before and after the staged robberies to discuss them and observe them from across the street to make sure everything goes as planned. Now that we could confirm that the mastermind Noel was present at the scenes, we got a warrant for his cell site data, and sure enough, it placed him in close proximity to almost all of the robbery locations. And that would serve as good proof against him, but also back up what Jeremy told us and show him to be a truthful, accurate witness. The fact that some fraudsters came from out of state was also very helpful to us. If we could show these fake victims coming into the Chicago area, traveling to a bodega, being beaten and immediately returning to their home state, these movements alone would look quite suspicious. It would rule out any innocent explanation for being on scene. Local fake victims could claim they were in the wrong place at the wrong time as a fraud scheme played out around them. But a 2-hour stay in Chicago, followed by an asylum application being filed based on the visit, would foreclose such an excuse. Sure enough, the cell site data of the fake victims showed that most of them drove into Chicago the morning of their robberies and left the same day or the next day. We now had the robbers who had given statements and were ready to serve as witnesses. We had Noel and his scheme identified. We had records of Noel receiving tens of thousands of dollars, and we had cell phone contact between Noel and the victims, who had paid him. We had also geolocated all of the culprits, showing their suspicious movements during the scheme. But because my supervisors would only approve charges if they were completely airtight, I knew I needed more still. We needed some fake victims on our side if we wanted to charge Noel and others with this fraud scheme. We decided on a brute force approach, where we would interview as many fake victims as possible to amass cooperators who could thumb Noel. Many of the fake victims were already represented by attorneys. They had hired immigration attorneys to marshal them through the asylum process. According to the rules, if someone has an attorney, you can only speak to them with the permission of their attorney. We had a Homeland Security agent working the case with us who could access all of the asylum applications on demand. We pulled the asylum applications to find the names and numbers of the attorneys representing the several dozen fake victims we were aware of. It turned out that about 4 attorneys represented the bulk of them. The first time I called lawyer A, based in Georgia, it was to ask if we could interview her client, whom I'll call Luis. I explained that we knew this was a fake robbery and that we wanted to interview Luis. Lawyer A insisted that her client was truly the victim of a crime and not faking it, but that we could interview him. We interviewed Luis, who had exchanged texts with Pablo Noel prior to being robbed and beaten by his crew, and therefore was definitely not a real crime victim. But, as the lawyer had foreshadowed, Luis insisted that he was innocent. He gave us a bogus story about why he was in the Chicago area for under 24 hours. He had no real explanation for why he randomly popped into a Mexican bakery at 8 p.m. and drove right back home to upstate New York after being attacked. The lawyer said, "Look, maybe this was a fake stick up for fraud, but my client has no knowledge of that. He may have just been in the wrong place at the wrong time." A few weeks later, we looked into a totally different fake victim. Let's call him Javier, from West Virginia. He was from a different state than Luis and was present at a staged robbery weeks after Luis. But what do you know? He was represented by Lawyer A also. Lawyer A gave me a song and dance about how this client is innocent of asylum fraud too. Javier denied everything, just as Luis had. We tipped our hand more and more as the conversation went on to show the evidence against him and discussed that we could bring felony charges against him. We explained that it would be in his interest to cooperate, as we were mostly interested in the guy at the head of the scheme. He persisted in his denial. We interviewed many fake victims after this, and they all refused to admit to paying Noel to be a fake victim. We finally broke through when we found a guy who was present at a fake robbery, but did not seem to have filed for asylum and therefore was not represented by an attorney. I'll call him Mateo. Mateo was a Mexican fellow in his mid-40s. He lived in upstate New York, traveling to Chicago for the fake robberies months before, and again to sit for an interview with us. He walked into the interview room. I was impatient from being lied to so many times, so I started off with a blank question. Was this robbery real or fake? He cut straight to the point. "Sir, this was a fake robbery. I regret being there. I am very sorry." He bowed his head. He explained that he moved to America 2 decades ago. His 2 daughters were now college-aged, straight, students. They were both born here and citizens. He signed up to be a fake victim because he was terrified of getting deported and having to live separately from his wife and daughters. If ever there were a sympathetic culprit, it was him. I knew he would make a great witness. He took us through what had happened. One day, Mateo was complaining to his cousin that he still had no lawful status in the United States. The cousin told Mateo that he knew a guy in Chicago that could help Mateo with his immigration problem. The guy in Chicago could make Mateo a victim in a crime, and just like that, Mateo could claim that he's been persecuted by people from back home and get asylum. The cousin told Mateo to wait for his phone call for further directions. A few days later, Mateo got the call to head to Chicago and stay at a specific hotel near Chicago O'Hare Airport. Mateo decided to pack an overnight bag and make his way to Chicago so that he could get unceremoniously, but spuriously, beaten and robbed. Once Mateo arrived at the hotel, his cousin texted him to go to the coffee shop in the lobby of the hotel to have a meeting about the plan. Mateo went to the lobby, ordered a coffee, and found around him a veritable convention of asylum seekers, all speaking in his native tongue. He sat with them and waited when his cousin showed up. Mateo then found out that his cousin was a middleman between all of these asylum seekers and Noel. Mateo and the others, taking directions from Mateo's cousin, left the hotel in a car rented for them. They drove to a Mexican restaurant on the south side of Chicago. They waited together in a car outside. Mateo's cousin instructed them to walk in, order coffee and food, and sit together. Mateo was told to smile, laugh, and talk to these other fake victims, whom he did not know, as if they were all old pals hanging out. The cousin said that some guys would come in and act out the crime, and to await their entry. To make it look real, Mateo and the others would have to give the fake robbers empty purses and wallets. Mateo's cousin told them that when police showed up, they'd give police their names and phone numbers so police could follow up if need be, enabling them to later obtain help from the police, who would have to sign off on their story. When they got the signal to go in, they went in, and the rest of it went according to plan. Mateo saw the stick. Up guys barge. Through the doors. They put Mateo and the others on the ground, pantomimed hitting and kicking them, yelled, "Viva Mexico," barking out a poorly delivered bit invoking some fake political differences they had with these victims. Mateo paid his cousin something like $20,000, which he understood would be handed over to the real planner of the scheme, Noel, whom he never met or communicated with. Mateo was shown pictures of the other fake victims, and he identified them and detailed their conversations. Based on Noel's bank records, we had estimated that he made between $15,000 and $25,000 per customer. This was big business, because most staged robberies included multiple customers for Noel. For the staged robbery involving Mateo, there were 4 other victims. This meant around $100,000 for Noel. He probably threw Mateo's cousin a few thousand for helping set it up. And we knew Cristo Yarin and his crew split a paltry sum of a few thousand. But Noel was, by himself, raking in tens of thousands of dollars for each staged robbery. At this point in our investigation, we realized that Noel's staged robberies were occurring multiple times per week for over a year. So Noel had to be clearing hundreds of thousands per month. Wow. We built a compilation on the fake stick, UPS, as Noel and the robber squad tended to commit the crime in a similar manner each time, enabling us to convey the MO to local police, who in turn gave us all documentation of robberies and assaults fitting our description. The Chicago area police departments began supplying us with numerous reports of suspected fake crimes. We confirmed that they were happening almost every day, involving hundreds of fake victims. Our Homeland Security agent pulled the immigration files of the fake victims from these attacks, and sure enough, almost all of them went forward and submitted fraudulent asylum applications. Boldly enough, some of the people we interviewed who had lied to us went on later to complete their asylum applications and even send follow-up inquiries to USCIS seeking that their applications be approved. This was after we made it clear we were onto them. They simply did not take us seriously, believing they could handily manipulate the system without consequence. Once we had compiled the list of incidents, we investigated them, reviewing police reports and camera footage from within the locations. The further we dug into each individual robbery, the more gold we uncovered. For example, at one Mexican grocery store owned by a friend of Noel, they staged at least 5 shakedowns, all within about a year, without the local police department realizing anything was fishy. On one of the occasions, police body-worn camera footage showed Noel in the store, posing as a store manager, pretending to have been attacked amid the fake victims, telling police what had happened. We found other useful facts that would help us build the strongest possible case to enable federal charges. At several locations, we found in the footage that fake victims would often flash a little smirk on their face during their supposed robberies. It required zooming in at just the right time, but the knowing looks on the culprits' faces were undeniable. We needed all of the evidence under the sun to make federal charges stick in such an unprecedented case. To properly do our job, we had to dig deep and find the most eye-catching, shocking, and dazzling aspects of this asylum fraud scheme. If we did that, the case could get major public attention when we filed charges. And if a case gets a lot of attention, people considering engaging in the same criminal behavior might see press about the case and think twice. At the end of the day, fraudsters are calculating. They, above less thoughtful criminals, are ripe to be deterred from committing crime by making big cases against their confederates. If they find out that people are being busted for the same crime, they will take into account that they could go to prison if caught, which will sometimes cause them to back out of committing the crime. I uncovered a botched fake robbery where one of the fake robbers accidentally fired his gun, which I knew would be the type of eye-catching fact that could make this case a media story and help us deter future fraudsters. And I found it through a combination of effort and luck. As a prosecutor, I always tried to keep my ear to the ground whatever way I could. A simple way to do that was by downloading the Citizen app for my iPhone. On the Citizen app, people monitoring channels of police radios will post details of crimes occurring in your area. People passing by crime scenes can also report police activity and post real-time videos of the crime scenes so that those in their community know what crimes are happening around them. I was sitting in my home one night when I got a citizen notification. Convenience store robbed by gunman, store clerk shot and in critical condition. I called the FBI agent on the case. As it turns out, he had heard about this incident and was likewise suspicious that it was a fake crime. We joked that the clerk was a fake victim who wanted the asylum so badly that he was willing to get shot for it. Still, the fact that someone was shot made the attack seem like it had to be a real one. But on reviewing the report, we saw what we had seen in every other report with our fake robberies. An unusual amount of people in a retail location between 6 p.m. and 8 p.m., all foreign nationals from a particular region in Mexico who had no immigration status. The FBI agent on the case interviewed some of them to see if they would confess. As usual, the fake victims were unhelpful and gave confusing stories, maintaining the robbery was real. But I bookmarked this robbery in my mind, knowing I wanted it to be part of our charges one day. Then, the breakthrough came. We were interviewing a guy who had been hired by Pablo Noel to act as a robber. He was a guy with a history of committing real crimes, so Noel liked him for the part of the robber. We asked this robber about what Noel had ordered him to do when Noel hired him to commit fake robberies. The guy explained the process we had heard before. Other robbers had told us that some fake victims wanted to be roughed up a little so that the government would believe the crime was real and give them their asylum. So we asked this robber, "Did you guys ever do violence against the fake victims to make it look real?" His eyes widened. He sat back in his chair, pausing for an uncomfortably long time. We told him we would give him a moment to think about his answer, and we walked out of the room. My instincts told me that this robber knew something about the shooting at the store. Why else would the question about violence make him so nervous? If the violence was just a push or a slap that the fake victim consented to. When I returned to the room with the FBI agent, the robber said he was ready to talk. "Great," I said. "Now tell me about the shooting at the convenience store." He instantly spilled the beans. The robber was not involved with this staged robbery, but he had heard through the grapevine that a new fake robber was brought into the crew, a guy who was young and hungry to make money. The young robber was a little reckless, but Jefe Noel knew he would make the robbery look real because he was boisterous. His first staged robbery would be of the convenience store. Noel ordered the new young robber to wait in the area for his signal. The young robber, on Noel's go, went into the store, gun drawn. While acting out the robbery, taking the customary empty wallets from the asylum seekers, one guy moved too quickly for the young robber's liking. In a moment of sheer panic and instinct, the robber fired a shot from his pistol at the guy. The young robber was fired from the crew by Noel days later. We had a hunch that Noel may have visited the guy who was shot at the hospital, since it was his asylum customer after all. We interviewed hospital employees to find out who was on the visitor logs for the guy who was shot to tie him to Noel. There were a few illegible names and some fake names jotted down. One of them was quite obviously Noel's handwriting, which we had seen on checks he had written and scanned through his bank account. So in the end, Noel was careful enough to not put his name down on the visitor log. Still, the robber's testimony about how this shooting went down would enable us to include it in the charges, and therefore the case could pack a bigger punch that would send shockwaves across the community of fraudulent asylum seekers. We had compiled a litany of fake crimes. We had discovered all sorts of wild and crazy criminal conduct that I knew could make some waves and get the media's attention. This would bring us closer to our goal of charging a big, bold case that would discourage future fraudsters from trying it. We had a robbery where someone was shot. We had robberies where our main culprit stood in as a manager of a store and was therefore on a responding officer's body cam footage. We had cases where daring escapes from police were made, and cases where the attackers roughed up the fake victims with their permission. We had also compiled evidence that Noel was making millions from the scheme. Over hours and hours, I put together a behemoth memo to my supervisors outlining the evidence we had. I included every text message and call between the robbers, the texts and calls between Yaron and Noel, and the communications between Noel and his asylum fraud customers. I included voluminous financial data, cell site location information, summaries of witness interviews, and more. This is the level of detail required by the bosses upstairs at the United States Attorney's Office. They are very serious about making sure our cases are strong and airtight. Ultimately, they agreed with my recommendation to charge Noel and others with a conspiracy to defraud the United States asylum program. We charged Noel, Yaron, and multiple people who posed as victims and sought asylum. The indictment was filed on the public docket. FBI agents, with the indictment and the arrest warrants in hand, picked up the suspects at their workplaces and at their homes. I knew that the media combed the court docket daily checking for stories. So I scanned social media to see if the story was gaining traction from media outlets. Sure enough, I saw that a well-known and trusted crime reporting website called CWB posted a detailed story on it. CWB is an independent Chicago crime news source that has a large national following. Media members from around the country that keep their ear to the ground on Chicago crime news follow CWB. CWB, covering the case, could mean the story would get big attention. And one by one, most of the local news stations ran stories covering the case, some even doing live on-air segments from the storefronts named in the case. After local media like the Chicago Tribune covered it, several national and international sources picked it up, including Fox News, the New York Post, The Economist, and a few major foreign outlets. We had done the work, built the case, and got the message out to the public that this brazen form of fraud would not be tolerated. But beneath the headlines and drama, I knew the underlying truths of the case were less than cinematic. What the public saw was a clean federal takedown. What I saw was the months of tedium, the slog of building an airtight case when most of the characters involved were lying, hedging, or scrambling for an angle. The system only showed its sharp teeth in public after all the dull, grinding gears had turned in private. And that was the real story. A fraud like this doesn't happen because someone like Noel comes up with a clever idea. It happens because the system is porous, predictable, and vulnerable to exploitation, as everyone from the local police to the immigration officers are drowning in volume, rushing through files, and trusting paper that can be manufactured to order. Noel and his crew had simply taken advantage of that reality. We had stopped them, yes, but only after dozens of people had already gamed the process, vanished into the country, and left the system holding their paper-thin claims. In the end, our case was both a success and a reminder of futility. We had held a few fraudsters accountable, but the machine itself, the endless bureaucracy, the backlogs, the flood of applications would keep running. And for prosecutors like me, that meant the victories always felt temporary, as if the best we could do was patch one leak while three more sprang open across town. Bank robberies. Edgar Valdez. Bank robberies are a dozen in the Windy City, occurring every day except Sunday, when the banks are closed. The average federal prosecutor in Chicago is assigned their fair share of bank robberies to investigate and charge. Bank robberies are automatically considered federal territory because the federal government administers the insurance for most banks' deposits. In real life, bank robberies are not nearly as dramatic as they are on TV. The typical bank robbery involves a drug addict who needs money to get his next fix. Often it's a middle-aged man who walks into a bank and hands over a threatening note that says, "Give me the money or else." They usually make off with no more than a few $100s, or at best a few thousand. It never seemed worth it to me, given the consequences. As you may have noticed by now, the cases I worked on as a prosecutor were almost always more bizarre than the average case. Some say I have a knack for rooting out the eccentric, while others would accuse me of leaning into the dramatic. But none of it is exaggeration. For me, there was never a dull moment. The bank robbers I dealt with were no exception to this trend. I'll start with the story of Edgar Valdez. Valdez had already spent a good many years in federal prison for bank robbery. Valdez moved to Chicago from Mexico as a young man with his parents and sister and was immediately thrown into a life of poverty and chaos in a dangerous part of the city upon moving here. Worsening matters was that Edgar's parents were both severely physically abusive to each other and to their children. His neighborhood was gang territory, but Valdez miraculously never became involved with gangs. He steered totally clear of them. He spent his time protecting his sister from the horrific forces they faced inside of and outside of the house. This is what we later learned about Edgar Valdez during his sentencing, when family and friends begged the judge to take pity and give him a light sentence, trying to give context to why he had fallen from the light. Valdez had his tender side, but he also had a dark side. To cope with the vicissitudes of life, he turned to cocaine as a young man. He was gripped by a cocaine addiction for the rest of his life, up to and through when I handled his case. Valdez had trouble keeping a steady job, so he rarely had money for his next cocaine fix. This led Valdez to robbing banks for easy money. Bank tellers are taught not to put themselves in danger, so many of them will readily comply with bank robber demands, even if the bank robber makes them casually and calmly. Valdez was as calm and unthreatening as they come. He would waltz in with no ski mask, no weapon, and greet the bank tellers with a smile. "Hello there," he would say. "I am a drug addict, and ma'am, I really need my next fix. So this is a bank robbery. Everything will turn out okay if you comply with my demands. If you don't, well, I don't want to go there." He would point to his waistband, which likely did not holster the gun that he implied he had. Most of his victims were confused by this routine, rather than terrified. He would say strange things, telling female bank tellers how much they reminded him of his sister or his daughter. The whole escapade was carried out with a big, eerie smile. Because Valdez was only looking for enough for the next fix, he only demanded money from the registers right in front of him. This resulted in a few $100s, or at most a few thousand, being taken. The rare, more serious bank robbers will take tellers as hostages and try to clean out a bank for tens of thousands from multiple registers. Valdez, who was known to law enforcement everywhere, would take his payday and disappear. Long before I knew him, he robbed many banks in this manner. He gained the nickname the Quad State Bandit because he robbed 10 banks in 4 states in a matter of days. He was eventually caught and charged. He received a 10-year sentence for this 10-bank spree. Despite all of law enforcement's investigative tools, it took them a long time to find him, enabling him to keep robbing banks with impunity. I would later learn how he got away with it, and it was simple. Valdez was a master at hiding in plain sight. One day, I was on duty at the U.S. Attorney's Office, meaning I was tasked with answering the phone to take new cases from federal agents who called in. I got a call shortly after arriving at my desk. The FBI needed to charge someone with a count of bank robbery. Valdez had, shortly after finishing his prior sentence, committed more robberies to fuel his resurgent coke addiction. He was identified easily, as usual, and also as usual, he would prove hard to catch. Valdez had walked into a bank on a quiet street in a suburban downtown, the type that has one coffee shop, one restaurant, a movie theater, and a metro station. Surveillance footage captured him casing the bank for a few minutes. He pulled out his usual playbook, smiling at the bank teller and apologizing for robbing her, but menacing her enough that she had to fork over the cash. He got a few $100. Even in such a sparsely populated suburb, there were plenty of store cameras and doorbell cameras to capture Valdez's flight from the scene. Not far from the bank, a surveillance camera captured him getting in a red truck. The city had cameras at intersections, so we combed through the footage and got a clear picture of the license plate number. FBI ran the number and found that it belonged to a woman in her 42nd, around the same age as Valdez. The agents went straight to her house, which was near the robbed bank, and interviewed her. Surprisingly, she admitted to everything right away. She said she had let her boyfriend, Edgar Valdez, use her car earlier, but was adamant that she did not know he was a criminal. She said when Edgar returned her car to her, he had money tucked into his pockets and socks. She was also shown a grainy still image from the bank's surveillance footage and confirmed it was Edgar based on his appearance, his shoes, and his clothes. She had asked him where he got the money from, and he just smiled ear to ear. She said that moments later, he disappeared, and she had not seen him since. Knowing that Valdez was slippery, law enforcement tried to use his girlfriend as bait. Rather than reaching out to him directly to demand he give himself up, agents had his girl try to beckon him home. But Valdez had been burned too many times in his life. He immediately saw that it was a trap, and he began ignoring her calls. Agents started reaching out to him, and a couple of times he answered the phone and taunted the agents, indicating that they would never catch him. We had received a warrant for a ping on his phone. A ping involves live, continuous location data for a suspect's phone. Most phone providers have been nudged by the government into keeping E911 Phase 2 data. This data can pinpoint a person's phone to a location within a few meters of accuracy. The government implores cell providers to keep this data under the guise of locating people in an emergency when they call 911. But law enforcement uses it to find their suspects on the lam. Valdez had been caught before, so he was familiar with being geolocated, as it played a role in his prior apprehension. Despite having used his phone here and there, he had apparently turned off location services this time around. So the ping data came back blank. Over the next few weeks, law enforcement kept in touch with Valdez's girlfriend and his family members, but they all earnestly reported that they had not heard from him. Agents also put out a "Be on lookout," or BOLO, with his face plastered on a flyer in police departments so that officers would arrest him if they saw him. We had hit a dead end, so we simply had to wait. A few months later, on a mild autumn day, I decided to get my hair cut over the lunch hour. I had taken a day off work, and I had all the time in the world. I lived in a neighborhood of Chicago many miles outside of the city center, and dozens of miles away from where Valdez had robbed his most recent bank. In fact, I had not so much as thought of him in the past weeks, as I was busy dealing with people setting up fake beat down robberies for asylum benefits. The barber cutting my hair finished up, and I walked out to my car. It was unusually sunny for this time of year. I was around the intersection of Harlem and Montrose on the northwest side of the city. I got gas at a gas station on a corner of the same intersection, started my car, and began driving home. I made it one block when I got a call from the FBI agent handling Valdez's case. "Hey," she said. "Valdez just hit again. Northwest side of the city. The bank at the corner of Harlem and Montrose." "Very funny," I said. "So you're in the area, and you saw me, right? That's what this is about." She had no idea what I was talking about. As it turns out, while I was getting my haircut and filling up my tank, Valdez was robbing a bank right across the street. Unbeknownst to Valdez, the bank teller he robbed had slipped a die pack in with the bills. Die packs are small and inconspicuous, and can be snuck between bills by a bank teller. When the robber leaves the property, the die pack explodes, marking the bills and burglar, with bright red dye. Surveillance footage showed Valdez with his score soaked in red dye, smiling ear to ear. He did not bother with wearing a mask to hide his face. There are millions of people in the Chicagoland area, which comprises something like 10,000 square miles. The odds of this happening so close to me are astoundingly low. Yet, there we were. Despite being drenched in dye head to toe, Valdez successfully fled and evaded capture, with no leads as to where he went. Because the bank he robbed was less than a mile from my house, I kept an eye out for Edgar Valdez as I walked my dog. But no one had any idea where he disappeared to. A few days later, we had a breakthrough that got us close to catching our culprit. A woman walked into a convenience store down the street from the bank. She was a regular at the store, on a first-name basis with the staff. For years, she had purchased her daily bread and essentials at this store, walking from her nearby apartment, only buying as much as she could carry. On this particular day, she handed over a couple of dollar bills to buy some soap. The store clerk looked down at the bills and immediately noticed splotches of red dye on them. This neighborhood is a place where people pay attention to the goings-on. The store clerk had closely followed the story of the bank robbed nearby, and he was aware that a red dye pack had exploded on the robber and the bills he took. So the store clerk accepted her bills, told her to have a nice day, and called the police after she left. The clerk provided the first name and approximate age of the woman and explained that she was a regular customer. The clerk also remembered that the woman recently boasted that she had a new boyfriend named Edgar living with her. Employees of the store, around that same time, met a man introducing himself as Edgar and starting to shop at the store frequently. Edgar and the women did not shop together, but the employees inferred that they were together. Police showed the employees a picture of Valdez, and they confirmed he was the Edgar that they knew. Since Edgar Valdez was likely dating the woman with the dyed bills, we thought we'd find him in her apartment. Armed with her first name, FBI and local officers combed records of anyone by that name living in the several blocks near the bank and the convenience store. Records showed police officers responding to domestic incidents at a nearby apartment over the years, where the troublemaker was a woman by the same name. They printed out her photograph and showed the convenience store clerk, who identified it as our gal. Because we believed that evidence of a crime, the stolen bills were in the apartment of the woman, we could get a search warrant for her apartment and, more importantly, find Valdez hiding out there. To get a search warrant, you need probable cause to believe that a crime was committed, and that evidence of the crime would be in the location you want to search. There is no single, set-in-stone definition of what it means to have probable cause to believe something is true. I found that, in practice, it meant pretty darn good reason to believe what you believe, with nothing obvious contradicting it. Here, we had employees of a store who took red, dyed bills from a woman shortly after a bank robbery. The woman said her boyfriend was Edgar. Around that time, an Edgar started coming to the store, and the employees shown a picture of Edgar Valdez by the FBI said, "Yeah, that's him." So we had a sound reason to believe that Edgar was living with the woman and had the stash of bills at her place. I worked with the FBI agents to draft a lengthy search warrant application detailing who Valdez was, how we knew that he robbed the bank in my neighborhood, and how we knew that a search of this woman's apartment would yield evidence of a crime, if not Valdez himself. We included more details than you can imagine, even for such a straightforward case. The federal magistrate judges who review and approve search warrants can be quite stringent. A case may be airtight, but if one detail strikes them as off, they could deny the warrant. In most cases, though, a judge would not outright deny the warrant if they had an issue. They would just expect the prosecutor to gather new facts for the warrant to assuage their concerns. The magistrate judge reviewed the warrant and called me on my desk phone. "Mr. Moyer," he said, "I know this seems like an easy case. I understand the woman had dyed bills, that she has a boyfriend named Edgar, and our robber Edgar was identified by store employees as someone who shops in the same store, making you think this woman is dating our suspect, and that she is keeping the stolen bills and Edgar himself in her apartment. That's what you're arguing, right?" "Yes," I said, knowing he was about to make this complicated. "Here's my issue. What if this woman who goes into the store talking about Edgar has a boyfriend named Edgar, but it's a different Edgar than Edgar Valdez, who also shops at the store? What if, by total coincidence, Edgar Valdez also shops at the same convenience store as some other guy named Edgar who our lady is dating? I understand Edgar Valdez is guilty here. It's him in the footage robbing the bank, but we cannot really tie Edgar Valdez to the woman. And after all, you want to search her apartment. The woman and our Edgar have never been seen together by the employees. Edgar Valdez could have provided the stolen, dyed bills to another store in the neighborhood. They could have circulated around the community, and the woman could have received them as change from a store, therefore ending up with them innocently. This means your agents will be breaking down the door of an innocent woman. In my opinion, it was a stretch to propose this hypothetical, unlikely scenario as a reason to hold up the warrant. We had to prove that we had probable cause to believe the woman's apartment would house Edgar and the dyed bills. It was not required that we rule out every conceivable alternative scenario to the obvious one, but the judge was stuck on this possibility. Having been in these situations before, I crafted a possible solution for the judge. "Your Honor, what if we question the store employees again, and they recall the woman specifically referencing that her Edgar shops at the store? This makes it more likely that her boyfriend Edgar is actually Edgar Valdez, whom employees have already identified as the Edgar who shopped at their store. And what if we can also show that the employees are on a first-name basis with most regular customers, and there is no other Edgar that shops there than the one they identified for the FBI? Then we will know the woman isn't involved with a different, innocent Edgar, and she truly is connected to the guy we think she is, and they're sitting on the stack of soaked bills at her place." The judge agreed that this would help him rule out the possibility of second Edgar. The FBI agents quickly drove up to the store and interviewed the employees. They said that the woman had mentioned that her boyfriend was a shopper at their store, and that they knew of no other Edgar who shopped there. This let us connect the woman to the true Edgar Valdez, and it convinced the judge that the FBI would not be barging down the door of an innocent, unsuspecting couple. He signed the warrant. We received the signed warrant in the late evening, and the FBI search team lurched into action. I was eating dinner at a family friend's house. They lived in our neighborhood, but even closer to the bank, convenience store, and woman's apartment, probably under a mile away from those places. Agents surrounded the woman's apartment, with members of the team covering the exits. They approached the woman's apartment on the second floor and knocked, announcing that they were the FBI and had a warrant to search the place. The door opened, and Valdez blew past the agents, making it to the door, where agents grabbed him and put him in handcuffs. Valdez's girlfriend attempted to fight agents off, but was subdued quickly. Agents found the stockpile of stolen money in the apartment, and seized it. They took Valdez to the station and read him his rights. He was very polite to the agents interviewing him. He confessed to every bank robbery he had committed. He offered up his robberies before they even asked. Agents inquired how he had managed to avoid law enforcement so effectively over the years. He told them that he hides in plain sight, fitting in with the vagrants and vagabonds. A Chicago police station in the community had recently housed a large group of migrants who had come from Central and South America. The city was allowing them to stay in the lobby, sleeping in sleeping bags, taking donations of food from local food pantries and soup kitchens. Valdez learned about this and hid among these people, disguising himself as a migrant, only speaking Spanish. As he usually did in hiding, he wore a hat to cover his unique egg-shaped head, and he grew his facial hair out. Though he had a very distinctive appearance, these measures enabled him to stay under the radar. Valdez left the police station when he met the woman in the neighborhood, who quickly became smitten with him and welcomed him in as her live-in boyfriend. Valdez was charged with several counts of bank robbery. He could not afford an attorney, so the court appointed him one, a dedicated defense attorney. Fortunately for Valdez, the attorney appointed for him was like a poet when it came to highlighting the humanity of his clients and the difficult lives they lived, as a means of garnering sympathy from the judge. Valdez had given a full confession, so there wasn't much fighting to do on the case. He pled guilty, and we proceeded to sentencing. At the sentencing hearing, the attorney painted a vivid portrait of the difficulties Valdez had faced in life starting from a young age. The attorney also called Valdez's sister as a witness to speak about his redeeming qualities and to how he was a tender-hearted person, when not robbing banks to feed his resilient drug addiction. This approach was highly effective. The judge was a bad draw for Valdez because he usually gave fairly severe sentences. In this case, the judge went within the normal range for a bank robbery case, but on the lower end. The judge said that if Valdez had not robbed so many banks in his life, he would have given an even lower sentence. But Valdez had to learn his lesson once and for all. The sentence was around 7 years imprisonment. I was skeptical that Edgar would learn his lesson. After all, he had robbed 10 banks, served around 10 years, and immediately went back to robbing banks. Someone like Valdez had a charming, charismatic side, but to feed his drug addiction, he had desensitized himself into thinking it was okay to stick up innocent people for money. Henry Coburn. Many of the robbers I prosecuted were more menacing than Edgar. One in particular, I'll call him Henry, began his spree with quick, composed stick-ups, but his behavior escalated with each new robbery. During the first robbery, he simply handed the teller a note demanding large bills. By the end of his series of 3 or 4 heists, he had transformed entirely, waving a gun, yelling for everyone to get on the ground, shoving people aside, acting aggressive, volatile, and unpredictable. In the footage, you could see his eyes bulging as he forced people into compliance. The escalation in his tactics made the case a top priority for me, as I feared Henry might pull the trigger one of these days. We started with a single lead, the license plate of the getaway car, captured by a camera outside the bank. The agent ran the plate through the Illinois Secretary of State database, a system agents can access in seconds to identify the registered owner of any vehicle. They can also search by name, instantly pulling up a person's driver's license photo and related information. The car belonged to a woman who couldn't have been our robber because the robber was clearly a man. But agents knew our robber could be a brother or a boyfriend of the car owner. If we could find the man in her life who matched the suspect's general height, weight, and build, we still wouldn't have enough to charge him, not even close. But it would give us a direction. The FBI agent came up with a bright idea. He first got the woman car owner's home address from the driver's license database, which housed information you would find on the face of a driver's license. Next, the agent researched grocery stores and convenience stores located near the woman's home. We hoped that, by doing this, we would find footage from these stores showing the woman shopping, possibly with the male suspect, on the days of the robberies. This would help us pin her as the getaway driver and get us closer to identifying the robber himself. The agent had a smart way to narrow down the range of store footage from those days. He searched data from the city's license plate readers, LPRs, that were located right next to these stores. We could search up her plates to see if her car had passed one nearby the store. And what do you know? Her car had passed right in front of the store, hours after one robbery. Agents got a few hours of footage from the surveillance system of the grocery store located next to the plate reader that picked up our woman's plates. Minutes after the LPR clocked her car, surveillance footage from the store showed her parking her car. She walked in with a man by her side. The man was dressed, head to toe, in the clothing and shoes worn by the robber of the bank that had been robbed that same day, just hours before. In the footage, he was not wearing a mask, so we could see his face. Agents, who had surveilled the woman's house for a few days, recognized him when they saw a screenshot of this footage. They had identified the man as a guy who drove to and from her house in his car on several occasions. Surveilling agents had run the man's license plates through the system and found it registered in the man's name, Henry Coburn. We had probable cause to believe Henry was the bank robber, so we drafted the application for an arrest warrant and a warrant to search his apartment. On this occasion, we did not get pushback from the judge to whom we submitted the case. We could identify the man as Henry, clear as day, wearing the same clothing and shoes just hours after he robbed a bank in the same attire. As I've mentioned, judges often posited alternative scenarios to what the facts truly showed. They would then tell us that their dreamt-up alternative scenario made it difficult for them to find probable cause that the crime was committed. But in this case, that was not possible. The judge would have to believe that the man we wanted to arrest, Henry, was either being framed or was the unluckiest man alive, dressing in the same unique clothes as the robber, and hanging out with a woman whose car was the getaway car. Fortunately, we did not face such counterfactuals this time around, and the judge signed the warrants. The agents prepared their raid of Henry's apartment. Because he owned a firearm and was dangerous, they planned to surprise him bright and early at 6:00 and put him in cuffs and haul him to court, where he would face the charges. A large team of agents, armed with rifles and ballistic shields, approached his front door right on schedule. They knocked and announced their presence. Usually when this happens, people realize they've been caught by the FBI and the jig is up, so they surrender. Henry had no such plans. After clearing several rooms, ensuring Henry was not hiding in them, agents came down to one room with a closed door, knowing that Henry must have been in there. They tried to coax him out of this final room. "Henry, come out. We have a warrant for your arrest. You are surrounded." Eventually, he answered back, screaming that he would never go with them alive. Agents prepared to kick the door down. As they approached, they heard a loud bang as a single bullet splintered through the door. The seasoned FBI agent on the other side of the bullet hole looked down at his chest. Fortunately, he was not bleeding. But he looked at his ballistic shield, which he was holding in front of him for protection. The bullet had struck and cracked his shield. If the agent hadn't been holding his shield in the right place, he'd have been shot right in the heart. The agents, understanding the danger of the situation, retreated and set up a perimeter around the property. Over the next few hours, agents tried to negotiate with Henry by calling his phone and reasoning with him. The FBI negotiators spoke with him many times, hoping he would come out. But Henry sounded distraught and deranged. He told them several times that he was going to give himself up. But each time he changed his mind, launching into a verbal tirade, screaming at the agents that he was going to kill them and himself instead. The episode came to an end when agents heard a loud bang. They breached the door and entered Henry's room. They found him slumped against the wall with a gunshot wound to the head, the pistol still in his hand, plundering the public coffer. The days of the COVID-19 pandemic felt like a shared hallucination. City streets emptied to a hush. Office buildings sat vacant, while kitchen tables were transformed into workstations. Plexiglass was installed at checkout counters of grocery stores and in courtrooms. People stood in long, spaced outlines for toilet paper, masks, and hand sanitizers. Celebrities performed unsolicited, hackneyed covers of old songs on social media, much to the author's chagrin. Conversations with friends, family, and DoorDash drivers centered around the strange times we were living in. And strange they were. The legal profession grinded to a halt temporarily, then emerged with the advent of video conference platforms like Zoom. Judges and their staff set up virtual courtrooms so that lawyers, clients, and witnesses could appear for court over the internet and avoid breathing the coronavirus onto one another. In the spring of 2020, the federal government responded to the unfolding economic crisis with breakneck speed and a scale rarely seen in American history. Billions of dollars flowed overnight into newly created lifelines, programs like the Paycheck Protection Program, PP, and the Economic Injury Disaster Loan, EIDL, initiative. These projects were designed to keep businesses afloat until the virus could be tackled, which everyone hoped would be soon. They were designed to stabilize a country in freefall. While many recipients were small business owners just trying to survive. The rush of money also attracted a different kind of applicant, one at siphoning off a piece of the relief funds meant for struggling who saw opportunity in the confusion. Years later, in a federal courtroom, after Americans had returned to something resembling normal life, my colleague and I prosecuted one of these opportunists. The facts were stunning. Dozens of fraudulent EDL applications, fake identities, fraudulent companies, and millions of dollars siphoned off in the midst of a national emergency. It was a case that spoke directly to that odd moment in history. When the systems we rely on are stretched thin, they can become a massive liability. This wasn't just a story of pandemic-era fraud. It was a story of timing, audacity, and the human instinct to exploit a crisis. The case offers a window into how fragile even our best-intentioned programs can be when the world tilts off its axis. The defendant's name was Greg Diallo. By the time we need him in court, he had operated under more identities than a character actor. His scheme was bold in its simplicity. He created fake businesses by forging paperwork. He generated fake identities with fake social security numbers, and then he used these things to apply for as many EIDL loans as possible. He was correct in assuming that the system possessed inadequate safeguards to detect such fraud. From June to November of 2020, Diallo submitted dozens of loan applications to the Small Business Administration, each claiming hardship due to COVID-19, each backed by phony documents, and each aimed businesses. Many of his EDL applications were accepted, and in that short 5-month time period, the taxpayer paid Diallo almost $3 million for businesses that never existed. And that's not to mention the many additional EIDL applications submitted by Diallo that were denied once he was caught. Diallo did not just do this for himself. He brought his friends to his apartment, applied for and obtained EDL money for them, and did not even take a cut. They were thankful for his generosity. Like many federal defendants, Diallo was larger than life. Physically, he towered over most people, standing well above 6 feet and carrying enough weight to give him an imposing presence. His family came from an African nation, and he counted among his friends some prominent members of that country's diaspora. His inner circle included wealthy business owners, professional athletes, hackers, and tech experts. One of our witnesses, a compatriot of Diallo's, recalled meeting up with him once in their homeland. When they crossed paths, Diallo was surrounded by a sizable entourage, including several bodyguards armed with AK-47 seconds. The witness revealed that Diallo had close ties to the highest levels of government in their native country. My involvement in the case began when Greg Diallo informed the judge that he had no intention of pleading guilty, which meant a federal jury trial. The attorney who had investigated the case needed a trial partner, and I was assigned. I started combing through the file to make myself an expert on the case. Although I was second in command, I wanted to make myself as useful as possible to get good experience and to assist my trial partner. She had done phenomenal work on this case, uncovering evidence of fraud with a team of bright FBI investigators, led by a hard-working, experienced agent. My trial partner, working with the agent, had built a far-reaching profile on Greg Diallo. They traced his online activity, his bank transfers, deposits, and withdrawals, his communications with co-conspirators, and the submission of dozens of EDL applications. What emerged was a web of information that needed tying together for trial to demonstrate the main point. Greg Diallo and his friends made fake identities, claimed them to be owners of fake businesses, and lied to the government that the businesses were real and had lost revenue to get COVID relief money. It all started in 2020 when Diallo and his friends learned that the government was giving out loans to businesses in need. They were especially excited to learn that the loans were, in many cases, forgiven by the government not long after being issued. By forgiving the loan, they wiped out the person's debt, and they owed nothing, permitting them to keep the money and never pay it back. The U.S. government's Small Business Administration, SBA, was the agency reviewing and accepting these EIDL and PPP loans. They had neither the technology nor manpower to properly sort real applications from fake ones. So Diallo knew he could venture enough fraudulent applications to make a killing. But he knew that submitting the applications in his own name could trip alarms eventually. So he learned how to create fake identities that would pass the automated security systems. Diallo and his crew built fake identities using a process known in the fraud world as tradlining. It started with selecting a social security number that appeared valid but wasn't actively in use. Fraudsters understand the SSN format: 3 digits for the area number, 2 for the group number, and 4 for the serial number. They use this knowledge to construct plausible combinations of digits to approximate a valid SSN. With access to online tools and certain dark web databases, they could test whether a number fit the SSA's issuance patterns and wasn't already tied to a real person or flagged as deceased. Once they landed on a clean SSN, they'd buy a fake U.S. driver's license, often sourced from overseas vendors in places like Jamaica, featuring a random name and photograph of Diallo or whichever of his friends were seeking the money. The name and SSN combination became the seed of a new synthetic identity. The next step involved adding the synthetic person as an authorized user on an existing credit card account. Sometimes that account belonged to another synthetic identity already loaded with good credit. Other times it belonged to a real person, knowingly or unknowingly involved. Either way, the goal was the same: piggybacking on someone else's strong credit profile to quickly build a high credit score for the fake identity. Diallo and his friends were serial fraudsters, so they had multiple trade-aligned identities waiting to be named as owners of fake businesses in need of an EIDL. With fake identities ready to go, Diallo needed to work up the fake businesses. Using these fake businesses and trade-aligned identities, Diallo could claim that the businesses lost revenue during the pandemic so that he and his friends could collect the free payday offered by Uncle Sam. Diallo had previously opened LLCs for other reasons, so he used some of those. He created falsified tax returns in the LLCs, names to submit as proof that the business had income in the past, before the pandemic, when in reality, the LLCs were registered but never did any real business. With some of the applications, Diallo had his friends open new LLCs. They sent him the registration documents, and Diallo simply edited the PDF to reflect a registration month and year that predated COVID times. He also created fabricated tax returns and revenue documents to send with these LLCs. All in all, the SBA needed proof of identification of the business owner, the business registration documents, and proof of revenue. Diallo used fake documents for all of this, and it worked. The SBA's automated systems were unable to cross-reference the data submitted by applications with anything, nor did they have human reviewers manually making calls to other government agencies to see if the identities and revenue figures were true. So Greg Diallo and his friends made millions. The evidence showed that Diallo spent tens of thousands of dollars on flashy, gaudy jewelry. He checked into 5-star hotels, ran up hundreds of dollars in room service charges, and bought luxury sports cars. In a short period of time, Diallo added several zeros to his net worth and lived lavishly. He brought his entourage along for the ride, treating them to extravagant outings and showering them with generosity. To move the money, Diallo used the fake identities he had created through trade-lining to open dozens of bank accounts, through which he funneled millions of dollars in fraudulent funds. Diallo and his crew had taken meaningful steps to conceal their scheme. For street-level fraudsters, they were fairly sophisticated, but they made one fatal, amateur mistake. Nearly every economic injury disaster loan application submitted by Diallo was sent from his home Wi-Fi network. Despite all the layers of obfuscation, they overlooked a basic fact of online activity: your IP address can give you away. Every Wi-Fi router connects to the internet through an IP address, which is essentially your unique fingerprint as you surf the web. When someone enters a website, the receiving server logs the IP address used. Federal agents can subpoena internet service providers to identify who was assigned a particular IP address at a specific date and time. The internet service provider can then reveal both the account holder's name and the physical billing address associated with the service. The SBA collected and retained the IP addresses associated with every EDL application. Once they got around to minimally auditing, they noticed that a large number of applications, many of them obviously fraudulent, had been submitted from the same IP address. The FBI traced the IP to an internet service provider issued a subpoena, and received the name and billing address on the account. To Diallo's credit, he hadn't registered the internet account under his real name. But he'd used the same alias in other settings, making it traceable back to him. Plus, while the service wasn't billed to his home address, it was linked to an office space he rented nearby, an office that agents ultimately tied to him as his exclusive workspace. When they executed a search warrant at that address, they found mail, documents, and other items linking the space, and thus the internet service to Diallo. In the end, for all the digital smoke and mirrors, Diallo had left a direct line between himself and the fraud. What makes Diallo's mistake more striking is how easily it could have been avoided. For a few dollars a month, he could have. Subscribe to a virtual private network, or VPN, service. A VPN is technology specifically designed to mask a user's IP address. VPNs work by routing a user's internet traffic through encrypted servers located in other parts of the country or even the world. So instead of a website or government agency logging the user's true IP address, it sees only the IP address provided by the VPN server. Most VPN companies keep minimal or no logs of which customer is using which temporary IP address provided by the VPN. So they could not report to the FBI which temporary IP address was affiliated with a given person on a given day. And the companies are based in countries where data privacy laws prevent cooperation with U.S. law enforcement in any event. Even with a subpoena, federal agents often hit a dead end trying to trace activity back through a commercial VPN, especially one outside U.S. jurisdiction. Diallo didn't need elite-level operational security to take this basic precaution. He didn't need a burner laptop or to access the dark web. He just had to click a button in a VPN app. For all his planning, he overlooked a tool used daily by millions of regular people just trying to stream Netflix abroad or avoid targeted ads. And that oversight exposed his entire operation. To further pin Diallo to the crimes, FBI agents began trying to identify his confederates, hoping they would turn on Diallo. On a very small number of the applications, Diallo did not use a trade-aligned identity. He just put his friends' real names down. He used real LLCs owned by these guys, but faked their sales numbers to make it look like they lost loads of revenue and thus qualified for an EIDL. The FBI approached these fellows, who were actual business professionals with 9 to 5 seconds, and confronted them. Shocked that they were in the crosshairs of federal authorities, they agreed to cooperate with the FBI and testify against Diallo. In each of their cases, Diallo had created the fraudulent EDL application in their presence. These erstwhile friends of Diallo could provide the most direct evidence possible that Diallo knowingly and intentionally submitted false information to the government to get money. The KEO schemers also showed us hard proof in the form of text messages between themselves and Diallo. Diallo had texted them requesting information, like their business names and their socials, before filling out the applications later in their presence. With this evidence in hand, my colleague charged Diallo. She dealt with all of the typical pre-trial motions. The vast majority of times, a defendant reviews all of the evidence against him and will plead guilty. But Diallo was hell, bent on fighting this thing, so he demanded trial, and the judge set a date. With trial fast approaching, I was pulled into the case. I quickly learned all of the facts I could so I could play a major role. My trial partner told me I would be responsible for the closing argument, where I would have to summarize all of the evidence to demonstrate how we had proven 10 counts of fraud against Diallo. The case had its obvious quirks, but I had no idea how bizarre it would get. Diallo opted for a brazen, bizarre method of fighting his case, a method that involved representing himself, declining a lawyer, and declaring that the law simply did not apply to him. Diallo wasn't just a fraudster. He was also what we called a sovereign citizen, though he never used that phrase himself. The sovereign citizen movement is a loosely organized web of anti-government ideology masquerading as legal theory. Its adherents believe they are exempt from the laws of the United States, usually based on pseudo-historical nonsense about admiralty law, gold, fringed flags, or the idea that their legal names are corporate fictions created without their consent, which means they cannot lawfully be prosecuted. Odd, I know. I had seen this brand of courtroom chaos before. Sovereign citizens almost always insist on representing themselves, flooding the court with nonsensical filings, misquoted statutes, Latin phrases, and boilerplate declarations of personal sovereignty. They demand that the judge prove jurisdiction or produce the original contract, allegedly binding them to federal law. Some refer to themselves as flesh and blood men and disavow any connection to the person named on the indictment, claiming that the lettering on the charging documents denotes a separate legal entity. Diallo leaned into all of this. In his pretrial filings, he cited the inapplicable and imaginary law and declared that he did not consent to be governed. It would have been comical if it weren't such a drain on court time and resources. The irony is that while sovereign citizens claim to reject the authority of the state, they're often the most demanding users of its machinery, filing endless motions, invoking non-existent laws, and forcing judges and prosecutors to respond to every incoherent theory with procedural precision. Diallo tried to hide behind that fog of legal gibberish, but in the end, reality has a way of asserting itself. You can only deny the court's jurisdiction for so long before the marshals show up with handcuffs. Diallo's friends were cooperating against him, so he built up a new crew of supporters, his sovereign citizen buddies. I have no idea where or how he met them, but they came to court dressed in colorful, eccentric garb, scoffing every time the judge made his decisions, even routine and neutral ones. The judge permitted the most disruptive and annoying among them to sit at counsel table with Diallo and basically act like his attorney. Since Diallo represented himself, he was entitled to this, much as a lawyer is entitled to have an assistant or paralegal help them during trial. On the day of trial, we came to court prepared with all of the evidence on our computer ready for presentation to the jury, with the witnesses lined up and ready to go. The trial began, and we went about putting on our case, questioning our witnesses. But every couple questions, Diallo said, "Objection," and offered an incoherent reason for objecting to our evidence. He was being fed lines by his makeshift attorney, whose face carried the calm, knowing expression of a seasoned attorney with decades of courtroom experience, wise, measured, and unshakable. But this man was nothing of the sort. Just a strange man voluntarily spending day after day in a courtroom, feeding his friend cockamamie legal theories that had no purchase in a federal courtroom. Many of our witnesses were Diallo's own friends. They testified about their text message conversations with him, messages we displayed to the jury. These friends authenticated screenshots showing Diallo asking them for business documents, social security numbers, dates of birth, and other information he would need to submit an EDL on their behalf. We then walked the jury through follow-up messages in which Diallo sent them doctored records and inflated revenue figures, all intended for use in fraudulent EIDL applications for their approval. Each case, the friend would then go to Diallo's apartment, where he finalized the scheme by clicking send and defrauding the government. One of Diallo's closest friends, Hugo, was our star witness. Hugo had helped Diallo create many of the trade-aligned identities that were used as the nominal business owners. Hugo was just as much of a fraudster as Diallo, involved with all sorts of questionable activity before the COVID era. In 2020, once the friends discovered that EDLs could be obtained with some edited PDFs, Hugo let Diallo take the lead and spearhead this new chapter of scheming. Because Hugo had allowed and abetted Diallo's filing of an EIDL for Hugo's benefit, and Hugo gladly accepted the payout, he was charged with fraud. But Hugo had no designs of fighting this case, realizing he had been caught red-handed with his name on an application and text messages on his phone revealing how it was all set up. He agreed to cooperate against Diallo in the hopes that his cooperation would lead to a lower sentence. Hugo was a rather large, muscular man from a Western African nation. He was the type of guy who said the minimum number of words to communicate his thought, a master of brevity. Although he engaged in EDL fraud and plenty of other misdeeds before that, he was a nice enough guy who acted contrite and embarrassed about the life he had led. Usually, I did not buy the mea culpa of the guy who is only sorry because he's caught. But I bought it with Hugo. When he spoke about his crimes, he hung his head. His eyes got a little teary, a light enough shade of red that would be hard to fake. Cooperator witnesses can be poorly received by a jury because they have an ulterior motive in testifying, the hope of avoiding jail time. But Hugo took the bite out of that because of his remorse. My colleague did the direct examination of Hugo, taking him through how trade-aligning fake identities worked, how he and Diallo had created the trade-aligned personas to use in fraud schemes over the years, and how they targeted the EIDL program when the opportunity arose. She also had him come clean about receiving his own EDL payout and applying for, then receiving, sweeping loan forgiveness for the loan. The jury seemed to follow what Hugo was saying, and they seemed to believe him. By thumbing himself as a culprit, it lent him credence when he took Diallo down with him. My colleague basically guaranteed a verdict of guilty through her questioning of Hugo, who gave truthful, fulsome answers to the questions. Undeterred by Hugo's powerful testimony, Diallo and his ersatz attorney wanted to go down swinging with Hugo's questioning. Diallo, representing himself, asked all of the questions, and he did not have the polish of a seasoned courtroom attorney. He would ask witnesses a question, receive the answer, and proceed to shuffle through random papers while he dreamt up another question, occasionally leaning to his fellow sovereign citizen for ideas. He barely strung together coherent examinations of our witnesses. His theme in crossing his friends was the following: I helped you all get a few $100,000 in your pockets, so I should be found not guilty of pilfering millions for myself. His cross-examinations involved guilting and chanting his friends for turning on him. And Hugo, his closest friend of all the witnesses, bore the brunt of this treatment. Diallo asked Hugo, "You would consider me a great friend, yes?" Hugo, in characteristic fashion, looked up in the air and furrowed his brow as if conjuring a profound truth. He then took an annoyingly long pause, as he did with every question given to him. He finally answered in his strong accent, "I cannot say." "But Hugo," Diallo continued, "we were friends, weren't we?" He seemed to be asking for his own consolation, no longer trying to make a point for his legal case. Hugo then answered through a sympathetic but condescending smile, "Yes, Greg, we were friends. We truly were. But you know that we were business partners above all else?" Diallo then began hurriedly shuffling through his papers, looking at his fake lawyer, scoffing in disbelief that Hugo had elevated their business relationship over their friendship. "We were more business partners than friends." "How can you say that?" he added. Hugo, if you had to put a number on it, what % were we friends? And what % were we business partners? Hugo, breaking Greg Diallo's heart, stated, "You and I were 80% business, 20% friendship." Diallo struggled to invent a new line of questioning, and his questioning went nowhere after that. Hugo may have downplayed their friendship, but he was nevertheless credible in taking Diallo down. Hugo wasn't the only useful witness. We also called several retailers to show where and how Diallo spent his EDL money. EDL funds were only allowed to be used on business expenses, but Diallo spent the money wherever he pleased. One retailer was an auto repairman who testified about servicing a high-end sports car Diallo had brought into his shop. Diallo paid for the costly repairs using funds drawn from an account containing EIDL money. The EIDL program was, of course, not intended to bankroll luxury vehicles. It was designed to help small businesses stay afloat, covering essentials like payroll and utilities. This kind of testimony gave us concrete evidence that Diallo wasn't using the funds to buttress business. Shesh was burning through them on personal luxuries. He also purchased blingy, flashy, custom jewelry from a dealer in Miami, who also testified for us, revealing more of Diallo's binge purchases. Our only unpredictable moment in the trial came from the jewelry dealer's testimony. Diallo did his usual guilting, shaming the guy for testifying against him despite that Diallo was a paying customer. But then Diallo surprised us all, asking, "And after I bought that jewelry, didn't you invite me to your wedding that weekend?" To our shock, the jewelry dealer answered, Yes, I did. I'm glad you could make it." How bizarre, we thought. Diallo patronized a jewelry store one day and charmed the owner to such a degree that the man invited Diallo to his wedding on the spot. Before taking up the mantle of defendant and sovereign citizen, Diallo was larger than life, befriending everyone he met, hooking people up with EDL money that they did not deserve, gaining favor with everyone in his circle. But justice came knocking for Diallo. Overall, our evidence was overwhelming, and Diallo did not help his case with his befuddling defense tactics. In the end, the jury convicted him on all counts. I wish I could tell you that the Diallo saga ended there, but sadly, it did not. In federal court, after a plea of guilt or finding of guilty by a jury, the judge sets a sentencing date. Diallo had not been in custody. so he remained free in the months before the sentencing hearing. Rather than hanging his head and employing some contrition, he invented up more obstructive plans. I was attending a court appearance a few weeks later for a separate case. I was in the hall, approaching the courtroom doors, when I heard behind me, "Hey, Mr. Moyer?" I turned around and saw that it was one of Diallo's sovereign citizen buddies. He smacked my chest with a folder containing a wad of papers. Rather hard, too. He cackled, "Ha ha, you've been served with a lawsuit, buddy." I instantly knew that Diallo had drummed up a baseless lawsuit against us to get himself out of trouble. Feeling the spine of the folder slam into my sternum, I saw red for a moment, envisioning myself shoving the guy to the ground, throwing the lawsuit paperwork back at him, telling him to stick it where the sun doesn't shine. But I realized how much work it took for this guy to find out where I'd be, how much joy it brought him, and I felt bad for him. He would have gone on to the Northern District of Illinois Court website, navigated to Search by Attorney, and entered my name. From there, he'd have clicked through the many dozens of cases my name was attached to, and found an imminent court date coming up on one of them, and hoped that I would actually be the attorney to show up, rather than someone else on the case. I'd bet he schlepped all the way to the courthouse over the past few weeks, trying and failing to serve me the papers. For him to get so excited, he must have had a sad life, dreaming that he could be a player in some grand courtroom drama. Ultimately, I just said to him, "You didn't have to do all that, man." And because I didn't react antagonistically, he had a guilty look on his face. Sorry," he said, and walked away. I looked down at the lawsuit papers. Diallo had named me, the other prosecutor, and the judge, accusing us of malicious prosecution, among other things. I later learned that Diallo's buddies served the judge with the lawsuit paperwork in open court, in front of other people. The judge, who was highly intelligent, well-respected, and kept an orderly courtroom, must have been vexed by this. Before I had to actually respond to the frivolous lawsuit, Diallo withdrew it. With his sentencing coming up, he got wise and finally hired a real attorney. The attorney he hired was a very skilled attorney who had a phenomenal touch in the courtroom. I had seen him do great work for his clients on other cases. I'm guessing the attorney convinced Diallo to withdraw his frivolous case so that the judge would consider taking pity on him. And when it came time for sentencing, the attorney put on a master class in humanizing an unlikable defendant. He had over 10 of Diallo's family members and friends attend court. They sat in the gallery, shedding tears, looking imploringly at the judge. The attorney took the judge through multiple letters of support written by the family and friends. They claimed that Diallo was selfless, that he would do anything for his friends, and that his desire for EDL money was born of his desire to give money to those he cared about. In my opinion, even if Diallo was generous to friends, he was fundamentally selfish and willing to plunder the taxpayer coffer to buy himself luxury goods. He also spent months filing frivolous paperwork to bog us down, not because he believed in the sovereign citizen movement, but because he thought he would waste so much of our time that we'd let him off the hook. He then sued us, which would have necessitated wasting even more time in dealing with the frivolous suit. Ultimately, the federal sentencing guidelines recommended a prison sentence of around 8 years. The guidelines were based in large part on the amount of money Diallo received by fraud. Thought he deserved at least that amount of time. But the judge deviated from the federal guidelines, giving Diallo only 5 years in prison. In Chicago, federal judges often impose prison terms below the federal guidelines. In my view, Diallo should have received at least the guideline minimum. His conduct, coupled with his obstructive antics, revealed a complete lack of remorse. The relatively light sentence surprised me. The sentencing guidelines are meant to provide an objective framework, a baseline from which judges can craft an appropriate punishment. But in practice, sentencing is inherently subjective. No rigid formula binds a judge to a particular number. My sense is that judges, even federal ones, become desensitized by the constant stream of chaos in Chicago. And that numbness inclines them to err on the side of leniency. Judges, I believe, shape their decisions by looking to the sentences imposed by their colleagues. Over time, an individual judge grows increasingly jaded. Each new generation of judges, in turn, inherits that jadedness from the last. The cycle repeats itself, with sentences drifting incrementally lower year after year. And so it goes. It's not necessarily the case that a lenient ideology drives low criminal prison terms. It's often just inherited desensitization. The judge permitted Diallo to remain free for a few weeks, giving him a surrender date a few months after the sentencing, so he could get his affairs in order to prepare for his prison stay. As a thank you to the judge, and in a final act of tomfoolery, Diallo attempted to obtain a passport. This could only mean he was trying to flee to his country of origin in Africa. He was taken into custody before he could fly the coop, and he began his sentence a little earlier than he had planned. The FBI and IRS agents on this case had investigated many EDL and PP fraud cases. I asked them to tell me, using their best guess, what percentage of money dispersed went to fraudsters. Honestly, one IRS agent said, at least 75%. Seeing how easily Diallo defrauded the SBA, this did not surprise me. I would later learn in other cases dealing with government loans and benefits that a gigantic portion of money handed out goes to fraudsters who do not deserve it. I handled another trial, a few years later, dealing with women, infant, and children, WIC, benefits. It was a similar case in that the culprits were fleecing the taxpayer as hard as they could. WIC benefits are like food stamps, in that they help impoverished people buy food on the government's dime. But unlike food stamps, WIC checks were only permitted to be used on highly nutritional items to help mothers and their infants get the nutrients they needed. Women would receive their checks from a WIC office. Each WIC check told them exactly which items they could purchase with the check. The WIC check also had a maximum dollar amount that it could be used for. In the case I handled, a network of grocery store owners allowed people to come in their stores with bundles of WIC checks, trade them for cash, and buy any items they wanted. The whole purpose of the program was to provide women with young children some extra monetary aid to buy healthy food to nurture themselves and their young children. Store owners enabled people to trade these government benefits for cash or store gift cards, which meant they could buy anything from benign items like paper towels to junk food to alcohol and cigarettes. And what was the benefit to the store owners? Instead of having, say, 50 customers in a day, they would have 200 or more. More customers means more profit. Word spread that the stores accepted WIC checks and converted them to cash, so business was booming. The store owners taking the WIC checks simply had to redeem them with the government, and the government paid them for the maximum value written on the check. Rather than reaping profits from 50 customers per day, the stores could reap profits from 200 due to the store's popularity. To increase profits, the store owners jacked up the prices nice and high. The store owners may have bought a crate of 2-liter sodas for $2 per bottle, but they would sell it at their stores for $8 per bottle. A CVS may, by contrast, only sell for $4 per bottle. Since the customers were using government money and not their own hard-earned cash, they hardly noticed the high prices, and they paid top dollar for things they were not supposed to buy with their WIC coupons. High customer traffic plus jacked up prices led to millions in ill-gotten gains for the proprietors. The FBI busted the ring of stores up, and we went to trial, where we prevailed in front of a jury, who found the main defendant guilty. This particular defendant and his friends took in millions of dollars of WIC benefits fraudulently over the course of a few years. I asked an agent what percentage of WIC benefits he thought were used on non-WIC items. He said, well over half. I asked the same about food stamps. He said over half of the transactions were fraudulent as well, likely closer to 75%. Around this time, I was looking to buy a house that would fit my growing family. I remember driving around in the summer in my 15-year-old car, which had no air conditioning, looking at homes with my wife. We realized we could only afford the most meager, modest hovels, given how little my government salary left us with after taxes. Tough luck, I thought, eyeing the exorbitant home prices, closing up shop. I recall chatting once with a Chicago police officer that was assisting federal agents on one of my cases. The officer told me about some disciplinary trouble he was having with the department recently. It all stemmed from a fateful day where his life was almost ripped from him in a flash. The officer, whom I'll call Cliff, was sitting in the police department when he got a be on lookout or BOLO alert. The BOLO informed officers that an old beat-up SUV with a bent fender was driving around his neighborhood. Witnesses reported seeing the SUV pull up, its windows slowly rolling down, then multiple pistols appearing in view. The shooters in the car peppered random victims with a volley of bullets. They were not targeting rival gang members. They were not committing robbery. They were hunting doe in an open field. The most horrifying criminals are those who shoot and kill strangers for sport. Cliff made note of the bolo because he lived in the neighborhood where the car had been seen. Cliff had grown up and still lived in one of the most war-torn, dangerous parts of Chicago and probably the country. He was a father of 2 young sons, struggling to raise them in such a hostile place. The day after the bolo was issued, Cliff prepared to take his kids to school. He packed their lunchboxes, got them dressed, and took them to the car, buckling them snugly into their car seats. He noticed he was low on gas, so he stopped at the gas station down the road to fill up. As he placed the nozzle into his tank, he got a strong whiff of marijuana smoke. He looked up and saw an SUV slowly rolling to a stop a few feet in front of him, blocking him in. The darkly tinted windows rolled down. Cliff saw several pairs of bloodshot eyes gleaming at him, each coupled with an ear-to-ear smile. One of the passengers held the gun in his hand, waved it side to side, and slowly nodded to Cliff, as if to confirm, "Yes, you are hosed." The man slowly trained the gun in Cliff's direction and fired shots at him. Cliff screamed, "Boys, get down." He lurched toward the driver's seat and grabbed his off-duty personal firearm. He fired several shots back at the beat-up SUV, shattering the windows as bullets from the SUV whizzed back at him. He heard a loud, pained roar from the back seat of the SUV, and it sped off. Cliff found his boys in their booster seats, sobbing with fear, their hands covering their ears, but unharmed. He hugged and comforted them as police cars arrived on scene, realizing what terrible tragedy could have befallen his young family. I wish I could end the story there, but Cliff's troubles were only beginning. Cliff was, as a police officer, allowed to carry a weapon while on duty. He also had all of the necessary licenses and permissions to carry his personal firearm on him when he was not on duty. However, Chicago police had an internal rule that its officers had to file paperwork registering any private gun they would be carrying off duty with the department. Cliff had registered his main personal firearm with the department, but that morning, Cliff had accidentally grabbed a pistol that he had not yet registered with the department. So, COPA got involved. The Civilian Office of Police Accountability, COPA, is Chicago's independent agency tasked with investigating allegations of police misconduct. Established to increase transparency and public trust, COPA handles complaints ranging from excessive force and abuse of power to improper conduct by officers. Unlike earlier oversight bodies, COPA operates separately from the Chicago Police Department, with the authority to conduct investigations, interview witnesses, review evidence, and recommend disciplinary action. Many officers feel that COPA's hidden agenda is to have officers disciplined and fired in any case that they can, rather than to neutrally assess their behavior. Despite Cliff's harrowing experience, where he was almost shot point blank, fearing for his young boys' lives, he was treated like a criminal for his violation of the departmental policy. COPA investigated and recommended that he be suspended from his job as a police officer. Cliff, in relaying all of this to me, did not seem mad or bitter. He took it in stride. He just lamented that he forgot to take his duly registered gun with him that day. Down is up, up is down. Every day feels like opposite day. In a city where chaos reigns supreme, those tasked with bringing order to chaos are battered by the entropy. The harder we tried to change the system, the harder it fought back, yet the wrongdoers, by contrast, experienced comparatively little bite back from a system that seems unwilling or unable to hold them to account. In the end, stories like Cliff's are not outliers. They are the daily currency of this city. The system strains those who try to hold it together, grinding down good people while allowing lawlessness to thrive unchecked. Justice here is less a steady beacon and more a flickering flame, constantly threatened by winds beyond anyone's control. Yet those who stand in the breach, officers, prosecutors, law-abiding citizens, carry on, not because the battle is fair or just, but because the alternative to fighting is far worse. The Windy City is a place where the fight for law and order is endless, imperfect, and thankless. This is a city that tests the limits of perseverance, demanding strength not only in moments of crisis, but in the quiet, sullen aftermath. Though the system may resist change, those who have faced it head on know one thing. Sometimes the greatest triumph is fighting like hell for as long as you can stand it, passing the torch, and moving on with pride. After years in criminal prosecution, I moved into personal injury law, a field that was built for me. I represent people of all walks of life, seeking justice and rightful compensation after they are injured through the fault of another. With prosecution, I wasn't just trying to win each case, I was trying to make a dent in a flawed and complex system. It was noble work, but it felt like swimming upstream. I could not shirk the feeling that I had to do everything I could to manifest improvements to a system in need of change. Now, I do not shoulder the nearly impossible task of changing the way justice operates on a societal scale. Instead, I channel every ounce of my energy into a far more focused mission, winning for my clients. I'm not chasing big policy changes. I'm chasing results. I fight hard as hell on each case, knowing that my clients rely on me to get them the best result possible. When I prevail, the victory is immediate and concrete, real money in the hands of someone who's been wronged, a measure of justice they can feel. This work strips away the politics and the bureaucracy. It's pure advocacy, uncluttered, straightforward, and rewarding. It allows me to do what I do best, turn every case into a fight worth winning. And win. About the author. Matthew D. Moyer is an attorney at Clifford Law Offices in Chicago, where he represents clients in personal injury cases, dealing with catastrophic injuries and wrongful death matters. Before entering private practice, he served as a federal prosecutor with the U.S. Department of Justice, investigating and prosecuting white-collar criminals, organized crime groups, and drug cartels. He began his prosecution career as a Cook County Assistant State's Attorney, where he gained extensive trial experience and handled some of the city's most challenging cases. Moyer's years in the courtroom gave him a front row seat to the drama, tragedy, and dark humor that unfold in Chicago's criminal justice system, experiences that inform American justice, from the front lines of the war on crime. A graduate of Boston College, B.A. Philosophy cum laude, and Notre Dame Law School, J.D., magna cum laude, Moyer brings both intellectual rigor and real, world trial experience to his work. He is fluent in Spanish, speaks beginner Serbian, and in his free time enjoys golf, chess, movies, and spending time with his growing family in Chicago, where he lives with his wife, children, dog, and cats. Movies, and spending time with his growing family in Chicago, where he lives with his wife, children, dog, and cats.